Well, good evening. Good evening to all of you. Happy Wednesday, November 8th. It feels like it's been a solid week and a half since I've talked to you. I know that's not actually the case because I did a recap on Friday, and then I went out of town, and then I had court today. But like I said, it feels like it's been about a week since I've talked to all of you. And what a past few days it was. What a past few days it was. So, I feel like I need one of those squiggly lines that goes like where we left off. Where we left off was a motion for sanctions that we anticipated forthcoming. So, that's where we left off with the discussion, but I guess I should go ahead and introduce myself. Hi, Rob from the channel Law and Lumber. I'm a practicing domestic relations litigation attorney, and I have been a practicing attorney for more than 10 years in that field of domestic relations litigation. So, trial attorney. We are continuing with our recap coverage of the Take Care of Maya trial. This is a trial that was documented in the Netflix documentary, well, the facts being documented in the Netflix documentary, Take Care of Maya, thus the name Take Care of Maya trial. It involves Maya Kowalski, who was at the age of 10 when she was admitted to Johns Hopkins All Children's Hospital on October 7th of 2016 with acute abdominal pain. In the resulting days, the hospital began to question that diagnosis, instead surmising that there might be some Munchausen syndrome by proxy or conversion disorder or some other type of factitious disorder that might have existed. The hospital then began to, after questioning that diagnosis, call DCF, Department of Children and Families, trying to initiate an investigation into whether there might be an act of medical child abuse. That resulted in a shelter order that was entered on October 13th. After that, Maya was sheltered at the hospital until sometime in February, when she was ultimately released. Along the way, during the course of her shelter, there were various allegations of the hospital exceeding the scope of the orders. The shelter orders granting the authority of the hospital to care for Maya during that period of time and setting restrictions on who could be around Maya or communicate with or bring things to her. So the allegations are that the hospital engaged in various activities, among them battery, false imprisonment, battery on various occasions, and then negligent and intentional infliction of emotional distress. The ultimate uh, claim in the case came about on January 6th and 7th. January 6th, when Maya Kowalski was brought to the hospital, or rather brought to court to testify to the dependency judge and tell the judge what she believed should happen in the shelter case. That day, before she was brought to court, Kathy Beatty is alleged to have disrobed Maya Kowalski, taken photos of her against her will, and not really under any permission granted by the shelter orders, but in her words, under the order of individuals at the hospital. Maya appeared at court, spoke her piece to the judge. The judge did not allow Maya and her mother to embrace. And the next day, on January 7th, Beata Kowalski took her own life. The month later, Maya Kowalski was released into her father's care. And thus we have the lawsuit. The plaintiffs are seeking $220 million. I think it was 238, I think maybe, from Johns Hopkins All Children's Hospital. And when we left the discussion, we had discussed, or we had seen that the defense had kind of, for lack of a better word, stepped in it. They had opened a door through one of their witnesses who had testified that the hospital was all well and good with CMS, Center for Medicaid and Medicare Services, as well as the Joint Commission and ACA. So essentially saying the hospital had the blessings of all of these agencies and therefore they were all well and good. Well, the plaintiffs had some information in their back pocket that wasn't fully drawn out yet, but that they intended to introduce in their rebuttal case. And introduce it they did. And on Thursday and Friday, there was required disclosures. Friday, they were supposed to sit for a deposition. That deposition got rather intense, as I can gain from the resulting motion that was filed on November 5th, motion by the plaintiff seeking sanctions against the defendant, Jay Hatch, and counsel for the defendant. So before we get into the subject that we're discussing here, and I forgot that there was a juror, the motion to dismiss jurors. Oh my gosh. Before we get into the subject matter of what we are going to discuss, I do want to say this is a sensitive topic, especially because we might be discussing some of the closing arguments, which were emotional and they did kind of get into subject matter that can be rather difficult for people to hear. So I have been leaving up this banner, an audience note, just to let people know that when they're joining in and tuning in, that they might stumble upon some testimony, or not in this case, but closing argument that they might find difficult to process. We were talking about the life of somebody and someone taking their own life and cause of action seeking to, well, recover for that loss. It can be rather sensitive material. So I want to give people the warning before they join. Oh, Sarah V. The thing is, you are so behind, my guy. My jury behind me is still sitting next to me. No, I have not yeeted the jurors. They're still next to me after the charity live stream. Um, for those of you who did go over to Ian Runkle's channel and participate in his charity live stream, I really do appreciate the heck out of you. I mean, it was pretty amazing what we were able to do for the benefit of the Stollery Children's Hospital. But I have not placed my jurors back on the bench in the jury box. So I am not really that far behind. I have played catch up for the most part throughout the course of my vacation period, listening here and there, much to the chagrin of friends when I have a little AirPod in, walking around and just listening at 2 times speed, trying to catch up on what's happening. Mostly because I wanted to kind of begin the stream tonight talking about the thing that kind of woke me right up on day 30. And it was right from the very beginning. Let me see. Give me one moment. And pull the video up, Rob. Pull the video up. But before we get to the video, why don't we just show the actual motion that was filed? Because people might want to see the actual motion that was filed before we start discussing it, or at least some of it. Because the motion was rather fascinating. It's not very often in the middle of a trial that you see come across the docket a 327 page motion for sanctions. 327 pages motion for sanctions. Like I said, not very often that we get to see something like that. I know that there are always allegations of misbehavior, malfeasance, unethical conduct. I mean, the things that get thrown at attorneys both directions when you're talking about trials is very often I mean, there's sensitive issues, and the job of being the attorney in those courtrooms is not the easiest thing in the world. I mean, you kind of are gearing up for that particular thing to be thrown at you all the time. This, however, was rather fascinating to me just because of how, I don't mean aggressive it was. Let me do this. Let me go to, I had an outline. I had an outline. I had an outline. I had an outline. Okay, hang on. All right. There's my outline. I found my outline. So what is this resulting from? This results from everything that kind of leads to, um, well, J Hatch having to put up a corporate representative to stand trial, or rather be deposed as to the various assertions of issues that were going on at the hospital around the time that Maya was treated. Okay. So the motion itself is 327 pages. I obviously cannot go through all of it. I would love to. But I kind of want to hear Mr. Whitney give us a summary of the highlighted portions, because he does a very good job at it. You all know that I love hearing from Mr. Whitney. Oh, and as a surprise, I don't know if it's a surprise. As a surprise, because I'm going to call it a surprise because it's my show. I can do that when I want. Um, you might have noticed a person that was on the thumbnail, a person that was on the thumbnail for today's video. Yeah, Ms. Lawrence, your argument. Oh yeah, we got to highlight that. We're going to highlight it. Yep. Needs to be said, needs to be highlighted. My entire purpose in doing a lot of these live streams on the recaps is at least once during these live streams, we're talking about subject matter of this level of sensitivity. We are going to highlight some good. Ms. Lawrence, for those of you who are asking, who is Ms. Lawrence? Ms. Lawrence is a young individual that's on the plaintiff's counsel's team who passed the bar during the course of the litigation, got sworn in this court, not yet in the Supreme Court of Florida, but sworn in this court so that she could actually practice as a lawyer in this court, passed the bar, found her results during the course of this trial. And throughout the course of this trial has been getting little opportunities here and there to expound upon her experience in a courtroom. I have loved this because, speaking as a trial attorney myself, I remember all of the impactful things that occurred as I was growing up in the practice of law. So I love highlighting these things because they're huge. We see a lot of negative things with attorneys. Why can't we highlight some of the good? Let's foster some of the good ones as they come along. So, Mr. Whitney, sir, if you wouldn't mind, on behalf of the plaintiffs, would you please give us a synopsis of your argument and motion for sanctions? We're going to talk through every spinning wheel tonight because that's just what we're going to do. That's what we're going to do. It's going to give me contentment. I had court today. I didn't sleep hardly at all last night. I'm awake.
Real concerns by mid-November that Ms. Beatty is improperly interacting with, counseling, advising their daughter. That issue should have been raised to senior leadership, including the CEO of the hospital. So those are the broad sweep of the failures that resulted in immediate jeopardy. It was cultural, it was systemic, it was improperly structured in terms of risk management. There was a culture of retaliation and retribution if you spoke up, and it all culminated in how Maya Kowalski was treated.
Now, I appreciate that. Where does that leave us with respect to proceeding? It sounds like you've got a lot of information already, and we need to address what the door that was opened by the defense in their case in chief.
Yes.
But it's we're not trying all these other collateral issues. It's just to meet what the defense presented to the jury, a fair shake of it, and then moving on. So can't we just do that with what you got this morning?
Well,
I mean, it sounds like you got a deposition of a senior individual at the hospital. You've got, perhaps you got it late, but you've got the documents. I'm assuming that your experts now seen them.
mm-hmm.
This is going to be a running theme. I made an appearance just in the chat on Recovery Addict. Kudos, by the way. Recovery Addict got to 50,000 subs today. Congrats to him. There's no one I can think of who's more deserving of that step up right now than Mr. Recovery Addict. Scott's done a phenomenal job. So I was watching Recovery Addict on this particular day, and today I popped into the chat and I was wondering whether to do a recap tonight because honestly, I'm exhausted and there's not a whole lot that I've actually been able to watch in real time. I've caught snippets here and there, and I've caught the bulk of a lot of this argument. But one of the questions that came across quite often was this question of why no sanctions? Will there be sanctions? My word, what was done was egregious. Why no sanctions? Will there be any punishment for the withholding of these documents until this late hour? And how unfair it is for the plaintiffs to have these documents thrust upon them at the very last minute and have to adapt. And the comment that I laid back or dropped back in the chat was, I'll talk about this. I don't know if people are going to like the answer that I have. but I will talk about it and I will kind of explain it. Trials are almost like a living thing. I know it sounds weird, but when I say it's like a living thing, they are things that have independent demands and needs, and you can't really predict what those demands or needs are. Sometimes the trial itself will get sick, and you have to attend to certain parts of that trial to fix it, to heal it. Sometimes that trial is just on top of the world until it's not, and it breaks a leg, and now you're in the hospital trying to get the trial some medical care. Really weird analogy. I understand it. Just follow me here. The fluidity that is trial is remarkably unpredictable. As attorneys, the reason we try to predict so much ahead of time, the reason we try to plan and strategize 5, 10, 15, 20 steps ahead is that you can't predict what's going to transpire. A witness could get sick. A witness could go sideways. You could have a witness that testifies inconsistently or consistently or leaves out an entire paragraph of information that you desperately need the jury to see. You could have documents that get ruled inadmissible for something that you thought you was a sure win. You could have documents that somehow magically show up on the last day of trial that you did not have a game plan for. You try to plan every contingency and you create an overall strategy that has a lot of those things in mind. That said, you can't strategize around everything. You can't. And a lot of it is on the fly thinking. Attorneys get paid. Let me tell you, attorneys earn their worth. Attorneys demonstrate their worth when they exemplify or they show you a remarkable amount of foresight and strategy in the ability to anticipate what is going to occur. And then a remarkable amount of thinking in the immediate, snap decisions, judgment calls on the fly. I mean, imagine a quarterback, might be a bad analogy, I'm not sure if it is, but imagine a quarterback that's playing football on NFL Sunday, right? Now, that quarterback's planned all week for this particular game, but that plan has some flaws in it. You don't really know how it's going to happen. Let's say that one of your offensive linemen goes down in the middle of the game. Now you have a rushing defenseman who's coming at you from this side unblocked. You have to improvise. You have to make judgment calls. One of those judgment calls might be that you step up in the pocket. One of them might be that you try to dodge to the right. Those judgment calls get measured almost independently. It's really important to think about this stuff because this right here was a strategy that the plaintiffs employed. Let's get this into the rebuttal case. Let's get to the systemic issues in the hospital. They employed that strategy. That has some hurdles with it when it succeeds. When it succeeds, it's, oh, we get additional information. But now we've got to fight it. Now we've got to fight to get it. And that fight takes time. And the time is really difficult to deal with when you're in the 11th hour of trial. Because there's very limited alternatives. You're up against the wall. The time is running out. You only have so much of it left. I mean, if lawyers had all the time in the world, they could compel any number of documents. They could compel depositions. They could force the issue. They could get sanctions. They could say, you've got to comply, but they don't have that. So they have to make a trade-off. They have to make a trade-off of what's more important to me, getting the documents I have in front of the jury and maybe preserving that argument to fight, or is it fighting that fight and maybe losing the opportunity for the jury to see these documents? And I know that people would like to believe that you can have both, but in the world of trial litigation, you can't. You just can't. It's a reality that you face. So when we started talking about the idea of sanctions and what the hospital did by withholding a lot of these documents, part of that is the natural consequence of the success that the plaintiffs had in their long-term strategy. And I don't know that we're ever going to see a sanction from that, especially if we get a jury verdict in favor of the plaintiffs. That might not feel right. It might feel really weird, but I want you to notice how much this argument kind of slips to the side a little bit in favor of let's get the documents in front of the jury and get the jury to have the case. People are making the comment of, isn't that the defense cheating? Maybe. I've gone against any number of attorneys who withheld documents that were completely relevant. And it wasn't until I got a motion to compel, which takes 2 weeks for me to get, that they finally turned them over. And even then, it was redacted in a format that I couldn't see. And I had to do a motion for sanction or to get it unredacted and sent over to me. It's time. It's tactics. Might not feel right, but they're available to the attorneys to do it. I told you guys you wouldn't like the answer. I try to give everyone warning. Yep, they were told that they had to give it. There you go. They were told they had to hand it over, and they still don't have a week later. Yep. I told you wouldn't like the answer, but I'm giving you the best answer. My job isn't to sugarcoat things and say there will be absolute fairness in every corner of the world. No, I don't do any good by that. That's not the benefit that you derive from this. When something feels wrong, I will tell you accurately that what you are perceiving as being wrong is in fact wrong. Is there a remedy to it? Not that I have seen take place. So why aren't they contempt? Why aren't they in contempt? Here's the thing. If a verdict comes back in Maya's favor, this is one that a lot of people can just kind of brush off as saying, well, look, didn't hurt him anyways. If the jury comes back in the hospital's favor, then the sanctioned motion is still there. It's still being considered. But, and then people are saying, is it going to be an issue with them with appeal? No. I think personally, I think that the sanctions issue is on the table. I think the hospital is likely to face a fine from the court. I don't know what though, because the judge gives them a judgment call. Like, do you want to get the documents in, or do you want to fight this issue and the sanctions issue all the way to its natural conclusion? The plaintiff's counsel knows that. Defense counsel knows that. So it's playing chicken with a train.
Can we just, is that a ruling or is that a?
No, I'm just asking a question.
Sure.
Can't we just, do you have enough so we can just go and finish this trial?
If forced to, yes, but we don't think that's adequate. And the reason is this case has had risk management central to it since before the court came on as a presiding judge. It's been up to the Second District Court of Appeal on this issue as to whether risk managers are sufficiently managerial to have the authority to bind the hospital and a punitive damages award be appropriate or upheld. So for us to attempt to unring the bell, unwind the clock over the course of 72 hours over the weekend, we think is severely prejudicial. So we have laid out a menu of options for the court in our request for relief. We believe that this was manipulated, intentional, contumacious by a clear and convincing standard because, as the court noted on Wednesday afternoon, defense counsel in this courtroom serves as primary outside counsel for Johns Hopkins Children's Hospital. Under questioning of the court, defense counsel admitted that he had an entire set of closed files on his computer. In essence, there's no way that as we were proceeding through this case, defense counsel was unaware or forgot about all of these systemic, cultural, and retaliation issues that were at the forefront in 2018 and 2019. We believe that conduct is severe enough to warrant the striking of defendant's answer and proceeding this morning on damages.
We'll take Maya off while I make this argument. Hello. I've got a list of options for you, Judge. For those of you who are not familiar with legalese, that literally equated to we believe the defense no longer has a defense and shouldn't be allowed to put forth a defense We get judgment in our favor. Let's just move to damages. He was like, whoa. I mean, if you're gonna swing for the fences, oh man, take a good swing. Wow. Good morning, Mr. Whitney. Good morning indeed, sir. You woke up and had your coffee. Oh my God. So, to those of you who are trying to play catch up, Mr. Whitney said, "We think this is egregious enough that you should strike the answer." That means their responsive pleading that says we did not do the things. The judge goes, "Nope, it doesn't exist anymore." It doesn't exist anymore. Move on to damages. I was like, okay, that's one thing. Did I just hear that? Did I just wake up and hear this morning? Oh my God. Oh, 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 heart palpitations. If I'm the defense, I'm starting to sweat real hard right now. Oh my. It's good. Yeah, and today, in the past 3 days, Maya Kowalski's been back in the courtroom. So if you see that I randomly pull the video down, it's because they just have her face up on the screen, and it drove me freaking nuts that they couldn't find. I, you know how much I would have rather seen Mr. Whitney and his facial expression saying strike the answer and move on to damages, and see Mr. Hunter's face in the background. You know how much I would have rather seen that image than the still image of Maya Kowalski reacting to this legal argument? Oh my God. Just yeah, it's driving me nuts. Every time there's argument being made, the argument that was just made, the request that was just made was to literally strike the answer. And we're not looking at Mr. Whitney, who's saying this audacious thing. We're looking at Maya Kowalski.
If the court thinks that's too severe, we think that given the history of this case, having been up to the Second District Court of Appeal, that the court should direct a verdict on punitive damages if the jury, after deliberation, believes that we have proven battery or false imprisonment. The counts that are subject
That's
to
on the
punitive
table.
damages.
That's still on the table.
We have been unable to develop the evidence on that over the course of the past 5 years, given the withholding of information. Third, if the court believes that is not appropriate, we have suggested, and it sounds like the court may have weighed into these. So I heard something about potentially directed verdict on negligent training. We think that could be an appropriate sanction. Third, and in combination with others, striking the testimony of Mark Anderson and giving the jury an instruction to that effect that his testimony was unreliable and misleading because even from him, material and relevant evidence was apparently withheld.
The second that he made that statement, the second that he said strike the testimony of Mark Anderson, I'm listening to this, and out loud I said to myself, well, then you don't get to bring in the dirt. Like, what do you want? Because if Anderson's out, you don't have anything to rebut. If you strike his testimony and give an instruction to give it no credibility or no weight, you don't get to go in and slam dunk on someone who the jury has been told to disregard. I get why it's in there. I wouldn't have left it in there. I wouldn't have even proposed that. I would have said, leave it in. Let me bash the heck out of it.
Fourth is what the court suggested a moment ago, that we proceed this morning. We cobbled together, and we have prepared an exhibit list, if that's how we do this today, with some of the more critical documents that we received on Friday evening. And we put Dr. Corcoran back on the stand, and he has the ability to talk about these issues and how they affected the hospital in 2016 and 2017, the time of my submission. And fifth, regardless of what the court finds appropriate from what we've presented here, sanctions against the hospital, attorney's fees for all these efforts, taking a deposition. I don't know how far back that we need to talk about that, but those are our suggestions to the court.
Thank you. Sure. Mr. Hunter.
Please, court.
Oh, here we go, though.
I'd like to address first Your Honor's question regarding how we proceed this morning and what's necessary.
Here we go, though. Mr. Hunter gets up. The hospital gets up. The hospital gets up via their attorney. And where does the camera go? If you are documenting real-time court proceedings, we don't need to see we don't need to see the parties responding or reacting. We don't care. Put a pool photographer in there to take those photos if you feel so inclined that you need to have them. Request that the judge give you that permission. If you are actually filming court for legitimate purposes of covering what happens inside a damn courtroom, please would you kindly focus the camera on the individual speaking, because that is what is relevant. That's what I want to hear. Those are the arguments I want to see made. That is what I care about. The double standard that is applied to the plaintiffs in this particular case and the defense in this particular case. Now, I don't particularly care for the fact that the spotlight is always on Mr. Hunter, because I feel like he does get somewhat of a negative shake in some of these proceedings. But can we focus on the attorneys, please? I understand that. I really do. What am I gaining from seeing Maya Kowalski sitting there? What am I gaining from that if I'm watching the court process? I know that others have ranted about this. I needed to add my 2 cents because I give a shit about these cases, and I give a damn about the fact that we can observe this and I can explain these things to all of you, because so many people are confused. The number of questions that I get, I didn't realize the significance and the importance of being in this forum and explaining the law in this fashion and how impactful it could be until I had the opportunity to do it to several of you, to all of you. And the notion that that could be deprived from us, that could be taken from all of you because the cameraman can't seem to figure out, or woman can't seem to figure out where to point the damn camera, has me, I don't know what to do. Do I, Court TV, or if anyone of you are watching, if any of you are watching or see this, plaintiff's counsel, anyone, if any of you see this, I want you to know that the people that are covering this case on this little thing called YouTube, I don't know if you've gathered, but there's been more views on these YouTube streams than there have been everywhere else. We don't want to see your client. We don't. We want to see you make the arguments. We want to see the attorneys make the arguments. We want to see the judge make the rulings. We want to see the back and forth. We want to understand what's happening in court. Give me that ability to explain what's happening in court. All right, rant over. Sorry.
Ready to proceed this morning. And in order to do that, I need to make clear to the court most of the information that was set forth in our filing on Friday of Angela Green's affidavit, as well as the disclosure that we filed. If you go back and you look at Dr. Corcoran's testimony.
Can I ask a question though?
Yes, sir.
So you file Ms. Green's affidavit and you file a motion for clarification, and in none of those did you attach the immediate jeopardy finding of what brought us here. Why did we omit the actual immediate jeopardy finding from your affidavit and from the motion?
Well, the point of the affidavit, well, first of all, the immediate jeopardy finding was in a letter dated 1/31/19, and that has been provided. But
It was not sent to the court as part of the affidavit. It wasn't part of your motion for clarification.
it was not.
I mean, you attached a whole bunch of other things saying how wonderful everything is. She didn't attach that.
Yes, sir, because the point of the filing was that the immediate jeopardy finding was immaterial and did not relate to the period of time that Maya was in the hospital.
So when I said to turn it over, you didn't immediately turn it over to the plaintiffs. You didn't even attach it and send it to the court. I mean, what am I missing here?
I think you're missing, Judge, what we're trying to get across in terms of what brings us here and what the real point of Your Honor's order was and what the real point of the testimony at issue here is.
So when I say to turn over.
Oh, please explain to the judge what the real point of his order was. This is going to go very well. I'm just predicting. Please explain to the judge what the point of his order was.
The immediate jeopardy finding, you're going to interpret that not to turn over the immediate jeopardy finding?
No, sir, Your Honor, we turned over the immediate jeopardy finding. By Friday morning, I have a list here of about 30 or 40 different documents that we had turned over to the plaintiff in less than 48 hours after this all occurred. I've also got since then a list of about 170 others. We've provided nearly 1,500 pages of documents that include the immediate jeopardy finding. Counsel interrogated Ms. Green in her deposition regarding the immediate jeopardy finding. And the immediate jeopardy finding, as she explained, was based on a site visit that the CMS did in January of 2019. If you read the report of that, which she testified about, you will find that all of the information that they gathered and all of the conditions that they addressed were set forth in that letter and related to that time frame. There was
I mean, when I went to look to actually read the immediate jeopardy finding, you didn't attach it. So how am I supposed to read it if you didn't attach it?
Judge, my apologies for not attaching it, but again, the point of the affidavit and the point of our filing was to attempt to clarify the basis on which there was any suggestion that the immediate jeopardy finding was relevant to the hospitalization here at issue. What I was trying to get across to Your Honor, obviously unsuccessfully, is the fact that the premise of Dr. Corcoran's testimony is based on two things. One is that the immediate jeopardy survey took place in September of 2018 and was a quote, look back, unquote. First of all, there was no survey in September 2018. And secondly, the surveys don't look back, they look forward. And that's the second point of the filing. It was to establish the fact that at the time of Maya Kowalski's hospitalization, what Dr. Anderson, or Mr. Anderson testified to, witness Anderson testified to, was that we were in good standing with JACO and CMS. The point of the filing was that we documented that that was in fact the case, that certificates had been issued in 2015 and in August of 2018, indicating that we had been reaccredited and that accreditation, barring any other activity and barring any other violation, was good for 3 years. The period of time that was covered by Mr. Anderson's testimony, Ms. Kowalski's hospitalization, was in the fall of 2016. During that period of time, we had been accredited by the Joint Commission, and we've got copies of the certificates we provided. They're attached to the motion. The point is that the entire premise of this, that the immediate jeopardy finding was somehow related to the status of the hospital at the time of Maya Kowalski's hospitalization, is simply not true. There was not, the immediate jeopardy did not relate to any of that. The immediate jeopardy did not base its findings on anything that took place during Maya Kowalski's hospitalization or that was even reviewed at that time. The point we were trying to make, simply put, is that Mr. Anderson's testimony, however brief and however summary, was simply correct to the extent that we were in fact accredited at that time, and that there was nothing untruthful or misleading presented otherwise to this jury. That was the point we were trying to make.
Was there a culture? Did any governmental agency or the Joint Commission talk about a systemic failure of the culture at the hospital?
There was a discussion of that finding. There was a discussion of failings of plans that took place in January of 2019 that did not relate to anything that was occurring in the fall of 2016, 2.5 years earlier.
How
There
do you
was
say
not-
that? I mean, am I just to take your word for it? I mean, how do I know that when the plaintiffs just told me they got evidence of systemic problems, which apparently Ms. Green talked about in her deposition?
Your Honor, with respect, Ms. Green talked about in her deposition findings that were made at the IJ in January of 2019. If you look at the report that resulted in the IJ, it's a report from CMS that has been provided that actually indicates what the basis of the IJ was. And it talks about interviews and it talks about evidence that was gathered in January of 2019 during a site visit between January 7th and January 11th of that year. And then it relates some of those failings to its interpretation of policies that were adopted in September of 2018. None of that reaches back the preceding 2 years to when Maya Kowalski was a patient. The whole point of this is the whole premise of Dr. Corcoran's assumptions, and it was an assumption. He looked at that report. He saw the date of September 20th, 2018, and he assumed from that there was a Joint Commission survey at that time that resulted in an IJ. That's been proven to be incorrect. And also it's been proven that that was not a look back situation. So the whole premise of this, the whole point of this is not what was going on at the time of the IJ and the findings that were made regarding the IJ in January of 2019.
All right. Let's fast forward a bit because we got to move forward. Mr. Whitney, 29, 23. Mr. Whitney, I think we need to dispel some
That you would like to say before I let
throw it
Mr.
around.
Whitney have a very brief rebuttal, and then we'll talk about what we're going to do.
I don't believe so, Your Honor.
Mr. Whitney, very brief, please.
I need to dispel a couple of notions. First, that these issues were limited to 2019. And what was produced to us Friday evening during the deposition, we have an ACA statement of deficiencies dated February 23rd, 2017, specifically for risk management deficiencies. The specific violations relate directly to patient rights, coordination of care, and patient family education. That was less than 1 month after Maya Kowalski was discharged. We provided that the first time from ACA on Friday afternoon. The statement of deficiencies and the corrective action that we were provided. Mr. Hunter just represented this court that surveys don't look back, they look forward. That's absurd. They have to look back. And in the corrective action plan at page, I don't know what page, I can pull it for the court if we need to. The Patient Safety Committee reported 12 retrospective Code 15s and additional Code 15 reported during the required time frame. They're not talking about the future. They're talking about the past. Ms. Green confirmed that in her deposition. In the corrective action plan provided Friday afternoon, the risk management department was not included on the organizational chart, included in the quality and safety plan. There was a failure to have them report to the medical executive committee, the president, the board, or the integration of risk management into the hospital organization structure and quality assurance program.
Just a few more minutes.
There was found to be retrospectively no evidence of risk management reports or data collection in the past 15 months and no historical data related to objective indicators of quality, all retrospective. The failure in plan of correction, the governing body failed to ensure management of the organization. That's how that begins. The interim president accepted the resignations effective immediately from the president, vice dean, the VP chief of staff functioning as lead executive of risk management, the chief patient safety officer, and the VP of marketing and communications and culture. The director of risk management was replaced by someone in the role of vice president of medical affairs. Mr. Anderson's testimony, you know what, the court already spotted the issue, that exchange about patient care. This goes directly to patient care. The last thing I'll say, Your Honor, is that we've been at this for just under an hour, and we admit that this is a lot to put before the jury on the final day of what's supposed to be the final day of this case.
Yep.
For that reason, we think directed verdicts are the most appropriate way to deal with this. Rather than bringing in Dr. Corcoran, introducing 15 documents, bringing in Mr. Anderson back, they want to bring in Angela Green now and have a mini trial on this issue. We think directed verdicts are the appropriate remedy.
The court has before it the question of sanctions filed by the plaintiffs against the defense. Ultimately, I'm going to be reserving on the question of sanctions. That's a bigger issue than what we have time to address today. And there's a lot of concerning issues that we'll ultimately have to work through. I need to address where we are right now, what we should do and what we should not do. I've got a situation where the defense knowingly and intentionally presented evidence to this jury that everything was fine at the hospital at the time of Ms. Kowalski's admission. There is evidence out there that can be viewed that there is a systemic culture of problems, especially centered in the risk management department. Now, absolutely, without a doubt, it does seem that the driving force was this Heart Institute issue, but there is a view of the evidence that plainly and without interpretation could be seen as being more pervasive than just isolated to the Heart Institute, that there's a view of this evidence that it is systemic, and systemic means systemic. And when we talk about culture, And I hear what the defense, they want it to view, well, look, this happened in 2018/2019, so you can't look back. Culture, however, is not something that you just turn on and turn off. It's not like a light switch or buttons on this wall that I can't figure out how to turn on and turn off. But it goes to the essence of what an organization is. And that takes time. And a 3-year look back from a time that we know that it was spotted by regulators, both governmental regulators and otherwise, suggest, or at least there's a view of the evidence that a jury could find that this pervasive culture existed at the time of Maya Kowalski's stay at Johns Hopkins All Children's Hospital. You know, this culture might even go all the way back to the time of Johns Hopkins purchase and acquiring of the hospital, which was, I think, 2011 or 2012. So I now have a situation where the defense presented everything is fine. And I think it's appropriate and required for the plaintiffs to rebut the evidence that the defense presented to this jury. Now, that being said, this is not a deep dive into what happened in the Heart Institute, what happened everywhere, but it goes more broadly and more high level as to what the culture was and the problems that existed, what appears to be admitted by Johns Hopkins All Children's Hospital. And I think if the jury hears that at the high level, that is an appropriate response for the plaintiffs to rebut what the defendants presented. And then we'll let the jury make the decision as to whether it's relevant or not relevant. I don't think we need to get into a situation where we have, 14 days of testimony as to what happened in the lead up to, okay, you can call them self-reports, but if they happen because the media outed you, I'm not sure it's a self-report, but that is a name. We'll call it a self-report. So I do think that there is a way we can proceed. So this is what I would suggest. Apparently there's 2 more boxes of materials. I see the plaintiff has his expert here that you spend this morning going through the documents and let the expert come on the stand and testify at about 1:30 today. Hopefully we can finish the evidence. And then I can give jury instructions this afternoon and the parties can do closing arguments first thing tomorrow morning. So, Mr. Whitney.
I was only going to say, I think there's a lot of those boxes, but we're not going to be able to have time to explore all that. And I think we have an hour and 20 minutes left in our rebuttal. I think our preference would be to, with what we have here, there's enough to put in front of him to discuss this at a high level now.
Strike his testimony, though.
And
as counsel said.
Anderson, stop tuning in.
In terms of timing, that's what I'm speaking to right now, is we prepared an exhibit list with 5 or 6 of these critical documents. We can get the issue in front of the jury for rebuttal this morning and hopefully wrap this thing up.
All right. That's what we end up doing. 3 hours and 31 minutes. So Dr. Corcoran takes the stand again. Now, Mr. Whitney, you have the opportunity to drive this this bus very carefully through. You have the opportunity to drive this bus very carefully through the window, bus-sized window / garage. That. Oh no, I'm sorry that the graph is covering closed captions. I'm sorry about that. I'll try to find a way to make it smaller. I was just kind of pissed off in the interim. So we now have a bus-sized hole in the side of this house, and Mr. Whitney is going to try and drive this through that carefully and quickly.
Good afternoon, Mr. Whitney. I promise this will be the last time. Let's talk.
Promises.
Let's talk about how Johns Hopkins All Children's Hospital was managed during the time of Maya Kowalski's admission. And specifically, I want to touch on how risk management was integrated into the hospital's organizational structure. Let's start at a high level. And the jury has heard some discussion of the Joint Commission. Would you reaffirm for the jury the role that the Joint Commission plays in hospital accreditation and governance?
Yes, so the Joint Commission is a nonprofit organization that evaluates hospitals and other healthcare entities on a recurring basis to make sure that they are in compliance with the regulations, conditions of participation that are really the owner's manual to how to run a healthcare facility like a hospital.
And you just mentioned conditions of participation. Are those derived
Looking at
from
guys.
federal regulatory guidance?
Yes, they are. So conditions of participation are actually published by CMS, the Center for Medicare and Medicaid Services, and they really form the foundation or the backbone of the accreditation process.
So we have the Joint Commission, it's a private entity. We have CMS, it's a federal entity. And then in Florida, is there also a state regulator that looks at these issues?
There is. The Agency for Healthcare Administration, also known as ACA, is based in Tallahassee. They oversee licensure and regulatory compliance for the state.
With respect to the governing body of Johns Hopkins All Children's Hospital, have you come to learn about self-reports of deficiencies at the governing body level to these three entities?
Yes, I have.
What have you learned in terms of self-reports to start with ACA in December of 2018?
I understand that the hospital leadership, sometime around the Christmas holiday, but probably just prior to, actually went to Tallahassee to address in person issues that had been identified within the hospital that put them at odds with the conditions of participation.
Was there also a self-report to CMS?
Yes, in the week prior to Christmas 2018, ACA was also in December of 2018, but in the full week prior to Christmas of 2018, a leadership group also traveled to Atlanta, which is the regional office for CMS, and had a similar conversation with the federal regulators about shortfalls that they had been identified inside the program.
And then, given these issues and these self-reports, did the Joint Commission also become involved?
They did. And that was done through a self-report that I believe was done either electronically or in writing on or about the 28th of November, 2018.
And so you had then both the federal and the state entity and the private nonprofit Joint Commission looking at and scrutinizing the hospital's management structure at that point?
Well, yes, they were looking at it from that point, but there also had been some visits earlier in the year as well.
All right. Did these issues manifest for the first time in December of 2018?
No. My understanding is that the issues were first identified at the end of 2015. So they were not new issues.
Let's walk through the timeline with some documents. So if we could please display 2811A, page 1. Dr. Corcoran, at the top of 2811, I see a header that says Agency for Healthcare Administration. Is that the Florida agency you talked about?
Yes, that's ACA.
Judge, I'm sorry, this doesn't say A, so I just want to make sure we're looking at the right document.
410. We're going to cross.
I thought you said A.
I'm sorry. My apologies. 2011. All right, we're looking at.
Undoubtedly true that they contributed.
All right, nothing further this time.
All right, so direct was okay. Got in all the dirt. Got in the dirt that says hospital had this culture of issues. Now, I was curious how Mr. Hunter was going to approach this. How are you going to attack this? Are you prepared? You haven't deposed this witness on this topic.
Good afternoon, Dr.
Good
Corcoran.
afternoon, sir.
You were provided a number of documents regarding various surveys, correct?
I saw several documents that involved surveys. Yes, sir.
Were you given a set of documents regarding a Joint Commission triennial survey from September of 2015
I saw the summary of it. Yes, sir.
that resulted in the Joint Commission accrediting the hospital, did it not?
In 2015. Yes, sir.
And that accreditation was good for the following 3 years unless it was revoked, correct?
That's correct.
And did you also see a survey, and incidentally, These surveys are fairly arduous events, are they not?
Typically, you've got 3, 4, maybe 5 surveyors on site for 3, 4, or 5 days. Yes, sir.
When you were at Brandon Regional Hospital, did you handle those?
I was absolutely involved in every day that they were on site.
Very,
Yes, sir.
very searching review, correct?
They were stressful. Yes, sir.
They went to all aspects of the
Well,
hospital, correct?
They did.
So when they did that at Johns Hopkins All Children's Hospital in September of 2015, they reaccredited the hospital, correct?
Yes, sir.
And then in 2016, they did a follow-up random review. You saw that, did you?
I don't. Could you refresh my recollection on that, sir?
Sure. Wasn't there in March of 2016 a follow-up review of evidence of compliance with the accreditation they had been granted the year before in March of 2016?
For improper way to refresh recollection.
If you're gonna refresh his recollection, once you show him the document.
Let me get that pulled up, Judge. Let me ask a couple questions first before I do that. Here you go.
Mhm. So while Mr. Hunter's looking for that document, let me just tell you, he's had the
Hey,
advantage of having these documents. in
you were
his
present
possession for
During
years.
Ms. Green's deposition the other night, right?
I was there. Yes, sir.
And were you provided a copy of the review done by the Joint Commission in March of 2016?
Mr. Hunter, I can't say with certainty that I was. It was Parents Weekend at my son's college, and I was up in Gainesville. So I played dad instead of expert witness this weekend. I can't tell you which documents off the top of my head, which documents I saw and which I did not. I certainly did not see but a small fraction of what was turned over.
Well, did you see a risk management survey that was done by ACA in February of 2017?
Again, I'd like to have my recollection refreshed. I don't recall which ones I'd seen and which I didn't see.
Did you
Just hand him the document if you.
Judge, I'm sorry that there's a stack of documents that were gagged 3 delegated to the maggots about this.
Mr. Hunter, whose fault is that? Just, I'm spitballing here. Whose fault is that there's a stack of documents that you don't have time to review? I'm pretty sure these documents were in your possession the entire time and you didn't think they were relevant. I'm also pretty certain that, this deposition took place on Friday. So you don't get to just say, are you aware that in this stack of documents, I mean, hang on, chat, are you aware? I mean, chat, focus, chat, are you aware that in this stack of documents that there's a document that says exactly what I want you to know that it says? Did you know that in this stack of documents, there's a magical document? Oh,
This tall.
I don't understand what that means.
Well, it's a lot of documents. And I don't have at my fingertips the ability to grab that particular document.
Do we need to take a few minutes so you can organize?
It would be very helpful, Your Honor.
Why don't we take 5 minutes? Members of the jury, do not discuss this case amongst yourselves. Do not do any investigation and receive no information. All right.
so we're going to come back in 5 minutes. For those of you wondering whether that is, in fact, the swoop, it is just jazzed up a little bit. I'm just not a tremendous fan of the camera right on her face all the time.
So the jury's aware you were provided a number of documents, or you attended a deposition Friday night.
I did.
Okay. There are a number of documents that you got to see as a result of that, correct?
Yes, sir.
Okay. One I just showed you, you said you'd never seen before.
I don't recognize it. It may have been introduced, but I don't recognize it.
Well, my question to you is, do you have any reason to question the proposition that in March and April of 2016, a joint commission survey occurred unannounced at All Children's Hospital and their accreditation was affirmed.
Objection, counsel testify.
Overruled. You can answer.
I'm sorry, can you repeat this question, please?
Yes, sir. Do you have any reason to question that in March of 2016, followed up in April of 2016, a joint commission survey took place at Johns Hopkins All Children's Hospital and that their accreditation was affirmed?
So there, I have no reason to question you. And that if accreditation was renewed in 2015, then unless there were a flagrant violation, the accreditation would not really be on the table at that time.
Well, wouldn't there be occasional random follow-ups to accreditation inspection?
Short answer, no. Most of the time, Joint Commission returns to a facility in response to a complaint or awareness of some kind of a problem.
So you've never heard in your long experience of random surveys taking place after an accreditation in the preceding years?
Objection, argumentative.
Overruled.
There can be follow-up surveys. When the accreditation survey is done, then CMS actually audits the work of the Joint Commission and will come in and do, I'm blanking on the term for it, but they will basically come in and affirm that the Joint Commission survey is accurate.
Okay. The document I just showed you was a Joint Commission survey, correct?
I believe so, yes, sir.
And you have no reason to question that it affirmed the accreditation.
Well, I don't think that was in the time frame. Typically, CMS comes back in 45 days or less. So I don't think that's the kind of survey that I was referring to, sir.
All right. Well, let's go with this another way.
May I, if you'll show me the document, I'm happy to do a quick review of it.
Well, I'll be happy to show you this and the two subsequent follow-ups from these compliance.
Sorry, squirrel brain. Just realized that attorney behind Maya ties a double Windsor. I always see the single Windsor knot, and I've never really been a fan. I'm a double Windsor knot, and I appreciate the throwback to the double Windsor. Can we bring back the double Windsor? It's a very handsome knot for a tie. I know that the new trendy thing is that little skinny single Windsor knot, but the double Windsor is a solid classic tie look. I'd like to see that with the spread collar come back, please. I just noticed that because I see that there's a cat riding a unicorn that's blocking Maya's face, and I appreciate having it there and putting it there, but it highlights the yellow tie in the back. Also yellow, solid color with a blue suit. Solid.
Just the three, or is that it?
This is different.
Okay. Can you give me a minute to look at them?
Sure.
Okay.
Perhaps, Mr. Hunter, you could return to the lectern.
That's Attorney Reyes, Jules. Clutch. And he's got the Alienware Heart laptop.
So on the survey done March 7th, which was unannounced by the Joint Commission, they found elements of performance where there was insufficient compliance. Social work consult for a patient on suicidal precautions was not performed until approximately 9 hours after. There was another element of insufficient compliance that related to utilization of moderate or deep sedation or anesthesia.
And were there, excuse me, were there indications of a follow-up that established compliance?
I'm looking for that in the next visit, sir. I just want to match up the EC.
And no, I'm not
This
covering Maya in every single
visit
clip.
that was
It's just when they
approximately
focus on her for
a
long
month
periods
later.
of damn time.
Is a survey addressing different elements of participation, different standards.
And it indicated compliance.
This shows compliance. This still has some outstanding issues.
And there's a
This is
subsequent that
great.
shows that was placed in compliance, correct?
Piece it 1 second, sir.
This is
So
great.
this survey dated 4/22, which is the 45-day evidence of standards compliance, does show compliance with the anesthesia related fallout, but not the leadership one. And this one, dated May 3, the 60-day visit, does show 040, LD 040105 is now compliant. So from March until May, they had issues and they corrected them.
And that's fairly typical of Joint Commission surveys, is it not?
Yes, sir.
Happened in your hospital, didn't it?
Many times.
An incident.
The fact that he owns it, that's the thing. Like, you can't burn a witness that's willing to own the negatives. Like, that happened in your hospital too, many times. But that gives him more credibility when he goes and clarifies how much more significant or different this one is. I mean, Corcoran, I thought he was decent. I thought he was a hired gun first. And then he gets brought back up, and I start to realize, no, he has actual motivations. Like, he has motivations for being here. He's not billing for his time in large part because I think he really does give a hell of a lot of a damn about what's going on in these hospitals. And the more that he testifies, and you know what, if Brandon Regional sucks, I don't care. The more that he testifies, it's more that I can tell he is almost offended by what he has seen. And he doesn't like the fact that they're trying to hide from it. So the motivations start to really shift for me as far as being the hired gun to actually really giving a damn. And the more earnestly and honestly he testifies, I'm really buying him. So the jury, I'm really curious to hear post-verdict interviews on how they took these witnesses.
Finally, there's a number of ACA inspections of your hospital, correct?
ACA is a
Hey,
frequent visitor
Torn,
to
glad to
most
see you
hospitals,
here,
sir.
bud.
Frequent visitor to Brandon Hospital, correct? For complaints and otherwise.
I will tell you, during my tenure, they were frequent but not overwhelming.
Now, isn't it also true, sir? Well, let me just ask you this way. You were given a report of an unannounced accreditation survey by the Joint Commission of Johns Hopkins Hospital in August of 2018.
Unannounced in August of 18, wasn't that when they had their re-accreditation visit?
Yes, sir. Yes,
And there was a second visit
yes,
the
sir.
same month?
Yes, sir.
I don't believe I saw that one.
Okay, but those visits resulted in reaccreditation.
Thanks
did
for
they not?
clarification.
Not the second visit. That's not a reaccreditation. They were reaccredited in August of 18,
Okay.
but that was their triennial review. Yes,
Okay.
sir.
So the point I'm making here is that in August of 2018, there was a triennial reaccreditation survey done by the
Right.
Joint Commission that resulted in reaccreditation, correct?
Right. And all of the violations were on the safer matrix in the lower, less frequent quadrant.
That's where you want them, right?
Amen.
So in August of 2018, the 3-year accreditation that was issued in September of 2015 was continued, correct?
Somewhat surprisingly, yes.
Well, editorial comment aside, it was continued, correct?
Well, again, given the presence of ACA Joint CMS starting in April of that year, yes, they got away with a remarkably
Gee, Mr. Hunter, why don't you feed him another opportunity to give you a line they got away with remarkably? Mr. Hunter, you do not have control of this witness. And you are at this point in time doing more harm than good. You should have just sat down because we're about to get into the point that he starts making where I think Hunter loses the entire argument.
benign evaluation. And it was, in fact,
And it indicates
reaccredited.
effort on their part to do that, correct?
Okay.
Incidentally, were you provided information regarding a CMS survey of all children's in May of 2017?
Again, can you show me the document? so I
Sure,
can
I'm showing the
refresh?
witness trial exhibit 2823-001, marked by 20.
Yes, this was a visit specific to the pharmacy.
Showed compliance, correct?
I believe there were no issues identified on that visit.
Now, let's talk for a minute.
Can I give a side note real quick? Dr. Corcoran stands up there when Mr. Hunter walks up to give them the document. I'm not one to suggest or say that that was a trained motion or that that was a motion that he, uh, well, Jules, if you're in the chat, can you let me know if he stood up the entire time that Hunter approached or if that happened after that prolonged time when Hunter was up there? Because I'm willing to bet that that was a new response to Mr. Hunter approaching with documents, was to stand up and meet him eye to eye. And I think that might have been intentional. I didn't notice that on prior exchanges. So
If we could, about some of the reports that council walked you through. Let me first have direct your attention to trial exhibit 2811. You can put that up, please. I'm not sure we need to see the details of it.
for those of you curious what I'm talking about, yes. On prior occasions, Hunter had approached the bench, and it is usually, you'll see attorneys do it in movies more so than anything else, because the attorney being present and pointing the witness to a question on a piece of paper, that can be viewed as intimidating. And judges will constantly admonish, please address the witness from the podium, because if you're sitting there standing over a witness saying, you see what I'm saying right there, and leaning over their shoulder, it gives an intimidating factor to the witness's testimony, and judges don't like seeing it. They don't like juries seeing it. This was really interesting, though. This, I think, was the first time we saw Dr. Corcoran do this, and it was after the judge admonished Mr. Hunter after he'd been up there for a long time. On the prior assertion, look at how he receives the document.
2017.
Again, can you show me the document? So I
Sure,
can
I'm showing the
refresh?
witness trial exhibit 2823-001, marked by Quentin.
Yep.
Yes, this was a visit specific to the farm.
And reads it and reviews it standing up. And reads it and reviews it standing up before handing it back. Not even caring about the microphone. Huh. I figured as much. Jules, thank you for confirming my suspicion. I liked it. Nice move. Good move. And I imagine that if here's the thing, I picked that up. One, I'm looking for it too, but I imagine the jury might have a perception of the power dynamic between the witness and the attorney. And they can perceive that a certain way. I might borrow that.
Show compliance, correct?
I believe there were no issues identified on that visit.
Now, let's talk for a minute, if we could, about some of the reports that council walked you through. Let me first have direct your attention to trial exhibit 2811. You can put that up, please. I'm not sure we need to see the details of it, but was there any indication in that report, and you reviewed that?
This is where you know that Mr. Hunter is fishing. Here's how you know where Mr. Hunter is fishing and he's in uncomfortable waters. He just made a very, 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 very classic trial faux pas. Can we put this up? I'm not sure the jury needs to see the details of it, or I'm not sure we need to talk about the details of it. Immediately, jury's going, let me see the details of this. Like, I'm not sure they need to see the details. Immediate attention of every juror. Show me the details. This is kind of how you know he's out on a ledge. He's out on a ledge. He doesn't know where he's going with this witness.
That's right.
I did this
Okay.
today.
Okay.
Yes, sir.
You testified about this a few minutes ago.
I did.
For counsel.
Yes, sir.
Okay, so were you aware of any joint commission survey of the hospital being done at the same time or around the same time as this particular report?
I'm struggling to answer clearly because there were so many surveys. Candidly, Mr. Hunter, keeping ACA from CMS is a challenge given the short timeline in my cursory review of just a part of the documents that you shared.
Let me show you what I'll represent to you as a Joint Commission correspondence from Mr. Sellers dated February 25th, 2019. Were you ever shown that?
Yes, this is a letter that documents the acceptance of the conditions of, I'm sorry, the plan for corrective action from the IP. Is that correct?
I believe you'll
From
see
the
that-
IJ, sorry, the immediate jeopardy.
I believe you'll see that that indicates that there was a survey done by Joint Commission at or about that time that resulted in a finding of compliance.
Score a point for Hunter. Yep.
Yes, the services at your hospital were
Score a
found to be
point
in
for Hunter.
substantial compliance.
That was a Joint Commission survey.
Hands up again.
And that was done 1 month
Boss
after,
move.
or 23 days actually, after the IJ. And 23 days is kind of that magic window that if you're not in compliance by then, you are at risk for losing your funding.
I'm glad you brought that up. So the IJ was issued by CMS, correct?
Correct,
All right. This is the Joint Commission.
right?
They're not the same thing.
They're not.
The Joint Commission found that there was substantial compliance. And the CMS was in the process of following up on the IJ, correct?
So it gets even stickier because the CMS surveys are typically handled by ACA surveyors.
Well, whoever was doing that, they lifted the IJ at about this time, February 25th, did they not?
They lifted the, well, no. What they did at that time was that they accepted the corrective action plan. The IJ threat was still in place until I believe late May or mid-June of that year. And in fact, the hospital requested and was given 2 extensions to comply. And then ultimately had signed an agreement, a binding agreement with the federal government that it would accept having a consultant in the facility for the next 12 months who would oversee or direct.
Okay, let me explain. At this point in time, J Hatch has had their IJ finding, and it's like, IJ, you're in imminent jeopardy. J Hatch goes, please, sir, please remove this IJ finding. Please, please, please. Here is our plan to get back into compliance. Please accept our plan of how to get back in compliance. And the government says, you know what, J Hatch? I will accept this tentatively, and I will appoint someone to oversee this plan. And because you've been a good J Hatch, we're going to remove the IJ temporarily. But keep in mind, you're still in the compliance period with your plan, and we have someone on site. So to say that they were free from the IJ, right? They were free from the imminent jeopardy, weren't they? Weren't they at this point in time? I would say no. But what would I know? Just me talking.
Correct the compliance, and in exchange, the federal government takes the threat of losing funding away.
But the IJ was lifted,
Again, they accepted the plan of correction.
correct? And lifted the IJ as a result, correct?
No, sir, because again, they were still under threat of being removed from funding until late May or early June.
But at that point, the IJ was ultimately lifted, correct?
At the end of June, yes. I'm sorry. I thought you were asking about that February date.
All right. So we can agree the IJ was lifted,
With an asterisk because of these
and we
extraordinary.
can agree that there was substantial effort put forth at compliance.
Oh, absolutely.
All right.
The new team actually,
A new
well.
team.
they worked hard.
Well, let me come back to that in a minute.
Pro tip, he does not come back to that in a
In
minute.
this 2811, where is the reference to nursing service?
This survey was conducted in conjunction with a risk management survey.
That's all, just risk management.
From what you're showing me, yes, this is a risk management survey.
All right. Where is the reference to risk management activities in the fall of 2016?
There's nothing specifically mentioned about 2016 in this unannounced complaint investigation.
Now, there was talk about trial exhibit 2815. Let me ask you, get that up if we could, Clay. And you talked about 4 areas that it addressed. And this is the announcement of the IJ in January of 2019, correct?
January 31, 2019. Yes, sir.
Okay, and that's January of 2019 is about 2 years after Maya Kowalski was discharged, correct?
That's correct.
All right. Now, in this statement of the grounds and the findings that are based on the IJ, with the basis for the IJ, where is the reference to the nursing service?
It's not in this letter. It's in the CMS 2567.
By all means, do you have that handy?
No, sir.
Well, in this letter here, is there anything basing the action on the hospitalist service?
Medical staff,
Medical staff in general,
right?
no specification to the hospitalist service.
Not in this letter. Again, this is
Where are you going with this? Where are you going with this? Do we need to rewind and see the front of this letter? I think we do. Because what tree are you barking up? Here are the issues. The facility does not meet the following conditions for participation. First issue, governing body. Okay. I would kind of view that as being like everyone up here. They're not doing it. Quality assurance, performance improvement. So basically, patient care and improving upon patient care. I would kind of view that as a remarkably large category of care and treatment. Section 3, medical staff. I'm pretty sure that includes like all the people, like all the staff. And then 4, infection control. But sir, you don't see hospitalists listed specifically, do you? No, but I'm pretty sure if I took categories 1, 2, 3, 4, they'd probably fall in one of those. But nurses, do you see them? No, but I'm pretty sure they fall in one of those categories. So, and the thing is, so Mr. Hunter is pointing at the individual people, right? He's going, you don't see the nurses listed here, right? Like you don't see them specifically listed. No, because that's not what this does. It's not aimed at the actual individual people. It's aimed at the systems. The systems.
Where is the reference to the nursing service?
It's not in this letter. It's in the CMS 2567.
By all means, do you have that handy?
No, sir.
Well, in this letter here, is there anything basing the action on the hospitalist service?
Medical staff,
Medical staff in general,
right?
no specification to the hospitalist service.
Not in this letter. Again, this is the overview, not the detail.
Okay, so the detail is in the 11119 form,
2567.
2567 in the lower left-hand corner.
Yes, sir.
Okay. So you looked at all 100 and some odd pages of it?
I did not see the version with the corrective action plan. I looked at the original document, which was 49 pages.
Okay. And I may have that in my hand too. I can't tell the weight of these things.
Fair enough.
But I was curious, in looking at this document, did you see any specific reference to the PICU intensivist service?
The intensivist physicians were not specifically mentioned. No, sir.
Nor were the hospitals, correct?
To my knowledge, no, sir.
All right. And you didn't see any reference to the pain management service either, did you?
No, but again, the issues that were cited are the ones that support them and also oversee them.
that
Right.
oversee them, but we're talking about them themselves, the people.
Yeah, and it's
Not
unusual.
special.
All right, Mr. Hunter, when you find yourself in a hole, the first thing is you put down the shovel. Please, sir, put down the shovel. You're not going to put down the shovel. You're going to keep digging until you're just satisfied. And you're not going to be satisfied here. So we're going to go ahead and fast forward. This back and forth goes on and on and on. Suffice it to say that all of this gets in, and the jury is left with the impression that this hospital had egregious issues. And the hospital's explanation for that is, yeah, but it wasn't like the individuals. It was just, maybe perhaps everyone up in the upper echelon. But it might not have been the individuals in that wing. The point of this wasn't so much focusing on which people were providing care, but it was kind of saying, look, if the hospital as a whole has some massive issues, is it a stretch for the jury to conceive that there might have been issues with those individuals that were tasked with caring over Maya, or not caring for Maya, those individuals that were making decisions? For example, hey, here's a good idea. Let's put her in a 48-hour room of monitoring. Let's do that. Or hey, let's find a reason to photograph her before court. Let's do that. You think that the jury can't make that connection? Sir, like, I know that when I flip forward in a video, that there's a spinny wheel that happens on the video, like as it's buffering. I know it's buffering for a period of time, and I get frustrated when it's buffering. But when you find yourself in a line of questions and you're in this buffer zone, hit pause, allow the feed to catch up, and then press play again and find yourself in a productive line of questions. Just my 2 cents. So that was my observations there. I want to fast forward now. Let me see if there were some super chats I wanted to pull up real quick. Gracie C, happy birthday to you. I'm very happy that you have a birthday. Happy birthday, Gracie. And to all of those celebrating a birthday on November 8th and November 7th. Happy birthday, Jack. Missed hearing the recaps. Thank you, Becky. Liz McFall, don't forget to do all the YouTube things. Yes, guys, please like the stream. It is my first time back after being absent for so long being Friday/Saturday. So please hit the like button. Christina, we've missed you. Rob, after this case, you need to break up with us slowly, but streaming 2+ nights a week. Don't break our heart by only seeing you on FNF. Honestly, I will try. It's difficult. 40 Doherty, will you do a recap of the whole trial/highlights? I don't know if I can. I can try to pick some points. Christy Stinnett, hey, Gavel and Hammer, happy to get your thoughts on the past few days of court. It's been spicy, and Whitney was fire in his closing, not a dry eye around. We're going to get to that in a second. I wanted to catch this one real quick. Miss Jules, Florida. MSJULSFL. Rob, I can't say much. Pediatric healthcare. My heart breaks for the retaliation in healthcare. Yeah, that's all I can say. I don't know if it's the retaliation against the system, if it's the retaliation against the employees that are trying to report upward. From what I have seen is that there's a whole lot that needs to be fixed in the healthcare system. And this trial is kind of shining a big light on it. So I hope that people are seeing that. Now, we're going to fast forward to my favorite part. 8:23. We'll catch it right about here.
The jury to do, which is if they are so inclined to ask questions, and he's using his skill and expertise as a former law enforcement officer to do that. And that doesn't mean asking sharp questions, as Judge Padavano points out in the Washington case. That doesn't mean that the juror has come up with any sort of final or fixed or violated any instruction in the court. So I don't think I need to say anything more on that. So I'm going to deny the motion to remove juror number 1 from the juror. Juror number 1 will remain on the juror. The alternate number 106, the retired electrician, will remain as an alternate. Okay, what's next?
Judge, we have some exhibit specific issues. We, given the number of exhibits, so not that many, but we were back and forth on the weekend on some of it is the language.
Are we talking about the neutral statement in the
Yes,
Excel
yes,
spreadsheet?
yes.
Okay.
So, exhibit 2165, Judge, is the access law.
Okay, 1 second. Let me recap. The judge did what I think I said would happen, Uncivil said would happen, Peter said would happen. Every lawyer that reviewed the motion to disqualify the juror was like, no, we're not doing that. We're not doing that. Now, the question is Mr. Anderson hesitated. Now, ultimately, he made the right choice because it's his client's call. His client is the one who gets to make that final decision over who is going to pass judgment over his client's case. I think it was the right call based on what he has perceived from this particular juror. I don't know if it was theater. I don't know what it was. You don't usually play theater with that. I think there was a lot of debate. Now, we did learn and confirm that it's former retired law enforcement. One of the things that I liked about this juror was the juror asked a ton of questions. They're engaged. They know the facts, but that's something that's scary to every attorney. They're engaged. They know the facts. If you get something wrong, they're going to know. So I think it was the right call. What, put on 0.5 speed for a very drunk Rob? Don't do that. I speak fast. Don't do that. That's rude. That's rude. No cocktails over here. We're behaving. I'm honestly just tired. Court today was fun. Not that, Mickey. Thank you very much for the very generous super chat. Hey, Rob, have you decided whether or not to watch the documentary? Would love you to do a commentary live on that. I can't comment on it live because I can't play that documentary live because I will get copyright struck faster than you could ever imagine. And then my channel would no longer exist. But I think I am probably going to watch it afterwards. I don't know that my reaction to it is going to be what you guys think. I view a lot of this stuff a lot more skeptically than you would imagine. I just try to be respectful of both sides when I talk about it. So I'll watch it. I will give it a watch. And I'll report back on what I think. But let's go ahead and get to my favorite part. My favorite part, the part that I've been waiting for, to be quite frank, this whole trial.
Log, and that's fine. But then for 2165A, which is just one page of it, they want to put Johns Hopkins All Children's Hospital access log. I'm fine with that. Access Dr. Sally Smith, that she accessed it that day. I'm saying you don't get to put why you put the access log in. It should be just Johns Hopkins All Children's Hospice log 10/8/16.
You know, Ms. Lawrence, you're going to be making this argument. Just to forewarn you, you're going to come up and you're making this argument. You're an attorney. You get to make the argument.
So that's the issue.
Okay. Ms. Lawrence.
They want to say why they put it in, that Dr. Sally Smith accessed it that day. I'm saying just the date of the access log gets put.
Can I see what the physical document is that we're talking about?
Oh, I don't know. Clay, can you put up? You're just.
So Mr. Cottrell's computer just crashed. So Mr. Reyes, can you help us out real quick?
His computer crashed?
I don't know. That's what I lip read over there. Am I correct?
Yeah, it's restarting. What's the exhibit number?
Sure. It's Defense Exhibit 2165A.
Okay. So let's talk the lay of the land here. The lay of the land here is that we're not really arguing something that's really massively in dispute. This is a relatively minor issue. The judge knows how he's going to rule. Ms. Crowells knows how the judge is going to rule. Carl's needs to make a record. Crowell's, who I think that you guys don't like. I personally have very much appreciated the fact that I have found her arguments to be well, I have appreciated her demeanor and her arguments. I have thought that they are founded in law for the most part. I think that a lot of people disagree with her. And I think the reason they do that oftentimes is because they have an emotional attachment to the opposite side that she's arguing against. I find that she has held probably some of the most credibility of the defense counsel in the room. And I think the judge also respects her, which should say something for you. Because when a judge respects the attorneys, they have seen both sides of it. And I will say this judge has kind of come down on Mr. Hunter, but as to Ms. Crowell's, he very much delivers even-handed remarks on evidentiary rulings. And when they disagree, he makes the point of saying, I understand you have a contrary opinion, and she'll push him on it and he'll push back. So I understand that people don't like the positions he's advocating for. Personally speaking, I have no issue with her. I think she has done a very good job. And when you talk about Judge Carroll looking over at Ms. Lawrence and saying, Ms. Lawrence, this is your argument, I want you to think about this for a second. This is a really big point. I want you to think about this for a second. Do you think Judge Carroll, being as encouraging as he has been throughout this entire trial of Ms. Lawrence and of young members of the bar, again, I have made no qualms about saying I am a big fan of this judge. Do you think that he, after a full trial where he's tried to highlight and bring this young attorney up and increase her confidence, do you think that he would throw her to the wolves? If he didn't respect Ms. Crowell's, if he had disdain for the attorney on the other side, do you think that he would take a young attorney and say, you make the argument against this attorney who's probably going to throw shade at you? He would not do that. So when you view Ms. Crowell's, I want you to think about that. Okay? You can find her to be disrespectful. I understand that. We disagree a whole lot in court. But this is a sign of respect that he is giving to a lot of people in the courtroom that I think went very much unnoticed.
Okay, Miss, well, let's bring up the exhibit so I know what we're talking about.
So Judge,
Which page of this?
that is just one page. It's 2165A. They put in the whole access log as 2165. They put this in as A. It's the access log from a particular date. I thought it was 10/7. Maybe it's 10/7. And we just say the date should be put on there. They want to put that this is the date that Sally Smith accessed the log. They want to put her name.
Well, do I see Sally Smith's name on here?
I think it's on there somewhere, Judge. My objection is that we've been neutral on all the other
Well, I
things.
see Matthew Higgins.
Yeah, there's other people. That's correct, Judge.
Right, but what I'm saying is, I'm not seeing Sally Smith, so is this the right page?
Oh, it should be. It's 2165A. That's what they.
What's the internal page number?
There's 234 pages, Your Honor.
Oh, I'm sorry. My fault. My fault, Judge. 71.
71.
Okay, Miss Lawrence, your argument.
Okay, it's a factual issue. It doesn't say that Sally Smith is an apparent agent. Everything else has been redacted, right? On the
Other pages,
on the
yes.
other pages. This is to orient the jury to see Sally Smith's name.
Anything else, Ms. Carls?
No, Judge.
I mean, the whole point is to help the jury find things, so I'm going to agree with Miss Lawrence's argument. We can leave in Sally Smith.
So what?
Okay. Look at that smile. Now, Ms. Crowells knew that she was going to lose that argument. She knew she was going to lose it. She knew what the argument was in opposition. She had to make the record. She had to do it emphatically. She knew damn well she was going to lose the argument. I mean, she knew the second judge says, Ms. Lawrence, this is you. She knows she's going to lose it. Look at the smile. Just look at that. Do you know how much that means to a young attorney? I guarantee you that woman just fell in love with the courtroom. She fell in love with the courtroom. So, cheers to you, Ms. Lawrence, on your first winning argument. Now, remember this one when you lose a lot more, because it comes and it hurts. But cheers to you for your first win. So, to you, Ms. Lawrence, cheers on the first win. That was my highlight for the last period of time. Why do I spend so much time talking about one young lawyer? Because I was once one young lawyer. Would not be where I am today without judges showing me that level of grace and judges showing me that it's not all miserable and torture, and judges telling you that they appreciate what you do. So, like I said, that was one of the coolest moments I think I have seen in a courtroom in quite some time. Let's watch it again. We're going to see the smile. We're going to see the win.
To see Sally Smith's name.
Anything else, Ms. Carls?
No, Judge.
I mean, the whole point is to help the jury find things. So I'm going to agree with Ms. Lawrence's argument. We can leave in Sally Smith.
So what exactly are the wording? So I have 10-8-16, and then you just want to put Dr. Sally Smith, access the log? I mean, Judge, that's, okay. What is the exact wording you would like?
I think however Kelly has it on there is fine.
Well, I don't have that because I changed it.
It's just
Just
tough.
put
I
Dr.
know
Sally
it's tough.
Smith? Is that acceptable?
You
Sally
already
Smith.
said it was access log hyphen Dr. Sally Smith.
It says
Yeah.
John Hopkins All Children's Hospital Access Log -10-8-2016. And then we can add Dr. Sally Smith. That's what you would like.
That works for me.
Okay.
Ms. Lawrence, as a reminder, stand for the duration of your argument. Even when you have won the point, stand because there's a follow-up argument. So stand. Remain standing. Remain in a neutral posture, but stand there until it's very clear that you have won not just the argument, but to come back to the argument. It's my only tip. Only tip.
The other one is, so Judge, to aid the jury, we broke down the hospital admissions with neutral indexes. It's just what they're called, right? So we did it for the joint exhibit for the hospital. And then we did it also for Lori and Tampa General Hospital records. Their objection is that it's not done for all of the records and it gives emphasis to these records. My response was break out what you want. If you want other records broken out so there's an index, so juries can find the discharge summary, or they can find consult notes or whatever, feel free to do that. They said we don't have time. So their objection is that on 3032, we broke out, and I'm happy to show.
Okay, we can finish that one there. We can finish that there. I know people are saying Carls get snippy with her. I didn't read it that way. Judge didn't either. Look at the judge's smile. Judge didn't either. So, okay, so those fireworks aside, what ended up happening next day? Oh my gosh, we got the closing arguments. Closing arguments. Oh, they finally came. I thought we were going to have possibly a verdict by today, but you know what? I went with my original assessment and said there's no way a jury is going to reach a verdict before Thursday. So I see the question in the chat. How long have I been practicing law? We're going on 12 years. Yeah, 12 years. So, yeah. And I was in a courtroom my first year as an attorney. Scary as hell. So that's another thing. I sympathize with Ms. Lawrence because a lot of lawyers don't start in courtrooms. I started in a courtroom the first year I was a lawyer. I know how scary that is. It is fucking terrifying. And I think if you want to ever hear my stories about that first year as a lawyer, first and second year. I replay them quite often when I talk about well, random happenings of my career. So, closing arguments. I don't really want to rehash the closing arguments themselves. I will give you a description. I think that Mr. Anderson did a very good job. I was concerned about how he would relay the argument. I was concerned with the fact that he can tend to get disheveled. But for the most part, I found that his closing argument was far more linear than I thought it would have been. He had a remarkable knack for the right tone in sarcastic remarks. Sarcasm is one of those things that can be completely lost in a courtroom, depending on delivery and depending on the jury or a judge that you're delivering the sarcastic remark to. They're very, very risky. The other thing about sarcasm is sarcasm doesn't translate to transcripts. So when witnesses try to be cute on the stand, I tell them, no, don't do that, because when I read that back in a transcript, it doesn't sound like sarcasm. It sounds like you're just being an asshole. Sorry. True. However, Mr. Anderson did a good job with the sarcastic remarks. What did the hospital have to gain in this? Well, I guess, $536,000, something to that effect. Very good delivery, very impactful delivery. He had good eye contact. He read from his notes, which was understandable. The thing is, what you guys need to understand, this is a 9-week trial. Taking all of the information and trying to condense it. I originally thought that I was going to get about I think I estimated 2.5 hours were going to be given to both sides for closing arguments. And that was based on kind of the judge and the judge's. Stop my brain from thinking. Take one step back. Had we been in other courtrooms during a 6 to 9 week trial, I imagine that you would see certain judges saying, each of you gets a half day. This judge doesn't play by those types of rules. You'll remember Judge Ascarati when we watched the Debt v. Heard trial. I think I told you guys, Judge A doesn't play with these long closings. No, you get an hour or an hour and a half or 2 hours, maybe that amount of time. This judge was pretty much along those lines, saying, no, I know it's 9 weeks, but you get 2 hours each. And 2.5 hours. Anderson did a good job. One caveat, and it comes with how they allocated the time. I don't know that Anderson had to focus as much of his argument on the wrongdoing as he did. There's a rule that exists in life, but we're going to translate it to lawyers. You cannot receive what you are desiring unless you ask for it. You have to ask for the thing that you want the jury to give you or the judge. That's why when I do custody cases or divorce cases, when I'm litigating cases, I begin my opening statement with this. Judge, at the end of this trial, I'm going to ask you for A, B, C, D, E, F, G. This is the evidence that I'm going to present to you that's going to convince you that that is the appropriate result. Okay? I lay out the roadmap. Boom, 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 boom. Here are the bullet points, and then I go through the roadmap of how I'm going to get there. In my closing argument, I begin the closing argument and I say, Judge, as I said during my opening statement, at the end of this closing argument, I'm going to ask you for A, B, C, D, E, F, G. Now, let me walk you through the evidence that proves why that is the appropriate result. And then I walk through and I tick off each of those remarks. And when I get to points, here's a good one. When I get to points that I very much need the judge to remember, I have been accused quite often for repeating things at length, for making comments and then saying the same comment again. That is a habit that I have picked up in the courtroom. I learned that when you want a judge to write a number down, you have to repeat the number. $135,000. $135,000. So you see that second time, if you've got the judge's attention or the jury's attention, they hear the second remark and they know, oh, okay. They write it down. Repeating numbers, repeating sentences are highlights. There are people that do it too much. Guilty. But there are ways of using it that I think should have been used a little bit more here. The math is hard in this case. Really, really complicated. Any personal injury case is freaking complicated. Let me explain. Here, we're going to pull up the one section of the closing argument that goes into some of the math from the plaintiff's side. Mr. Whitney does a very good job on a couple of key points. So we're going to lead off. So here comes Mr. Whitney. And I'm not going to go into the onward remarks. I'm not trying to make y'all cry again. I also have opinions on crying. I cried during my very first closing argument. It felt so weird. It was my very first full week trial and my very first closing argument on a full week trial. I remember arguing a case over a shared household or a primary custody household. And I remember arguing that. And I remember being so emotionally invested in the case that I was crying at the end of the argument. And it was so difficult. But what I realized is that when you are at that heightened emotional state, sometimes you lose track of where you need to make the points you need to make. And with that argument and with others in the future where I became emotional in making the argument, I realized there were points that were left on the table that I didn't make, that I wish I would have highlighted again, because the emotions were there at the forefront of my thought process. Now, the emotional connection you can still make. You can still make emotional connection with a jury. And there's sometimes you can't help but get emotional yourself. But when you know that a trial is going to make you emotional, you need to have that roadmap. You better have that bullet point list right there, man, because the second that you start getting teary-eyed, your ass needs to look straight back down at that piece of paper and know exactly where you left off, because any thought process that you're going to be getting logical in your head again for the next 5 seconds isn't going to happen. The case where I cried, I lost. I lost the argument. Now, I want to be fair. It was the losing argument. It wasn't the right call. It took me maybe about 3 years to realize that, after having represented family law cases over and over and over again. But got to be careful. You have to be careful. Your job is more important. Your job is more important than just displaying emotion or making the emotional connection. Your job is so important that you have to make sure that the information is conveyed and the argument is made. You have to be stronger than the emotion, and that's impossible, but you somehow have to do it. I applaud both of these attorneys, all of the attorneys in the courtroom, for doing their best to make it through all of the points they had to and still maintain that professionalism, but then get to tearful moments. They did a very good job with holding. Oh, side note, when you go home at the end of the night, after you've done all of this, there is an emotional unloading. Every human does it. And when you go home at the end of one of these cases, you will have an emotional, just emotion dump. And it's natural. It happens. Any attorneys in the chat will probably know. There's probably been a case that made you cry uncontrollably when you got home. All of us do it. We all have that one or two.
Now, January 6, 2017, you have conclusive, uncontested evidence in the record that on that date, there was a battery of Maya, and over her objection and tears, Catherine Beatty admitted that unfortunately they went ahead and did it at the direction of risk management. And question 18 is where you award damages for each of these categories. That's why I'm focusing on each of these, you make separate calculations. Pain and suffering is its own. Mental anguish is its own. Loss of capacity for the enjoyment of life is its own category. And each of them are going to be calculated for the past and future. And I recognize some of you probably have mathematical skills better than the others. So I'd ask you to lean on those folks as you're back there with a calculator trying to figure this out and do what you need to do to deliver justice. So let's go through some examples of how you would calculate for each of these categories. If you pull up slide 57 to begin. Well, this bucket of different categories I've just described here and pointed out to you, we've called them human damages. And so we're going to talk through not all of them because you have to do this for each claim. There are 2 separate battery claims. There are 3 separate false imprisonment claims. There's intentional infliction of emotional stress for Maya. There's medical malpractice. For each of these, you have to do this calculation. And then as Mr. Anderson was saying, once you come up with your total figure, then you decide, this PTSD and what Maya's suffering with, 50% of this was due to, and it really focused on this battery on January 6th. I don't know. That's your job. That's your job to allocate.
Math. This case has a lot of math. And I appreciate that lawyers have an opposition inherently, myself first and foremost, to math. However, you have to become the world's greatest and most interesting math teacher in personal injury cases. You have to be able to tell the jury not just that math is something you have to do, because what Mr. Whitney is doing here can be I got frustrated because it was like, that's your job. No, Mr. Whitney, you tell them what to do. You have to teach them what to do. You have to teach them what to do. And you can't gloss through it and do it quickly. You have to do it from a core principles level and walk them through one step at a time. And this is where I think the plaintiffs, I think they should have allocated more of their time. Look, the hospital got, if I'm being honest, that rebuttal witness kicked their teeth in. Make your points, make your strongest arguments on liability, and then explain how you get to the cost. Explain the dollar figure. $220 million is not an easy dollar figure to get to if you have someone skeptical of that amount. Make it easier. And when you're showing them slides, when we go through these slides, I want anyone to remind me or tell me if you don't feel like you're back in some college class or some middle school or high school class where the teacher throws up either a transparency or some chalk on a chalkboard and says, see how that works? And you're sitting there going, well, I see that there's numbers on a screen and I see the numbers there, but I don't know how that works. This is the hardest part of plaintiff's cases. The hardest part of plaintiff's cases. Make the math work. Make it something they want to do.
Once you have this final number. If we go to slide 59, please. I'm going to show you the first calculation here. All right. Maya Kowalski testified that she experiences and has experienced mental anguish 15 hours a day on average, if you take a good week and a bad week. Since this horrific saga ended at Johns Hopkins Children's Hospital, it's been 6.82 years. You can check our math on that. That's to the day since she was discharged. And if you apply the rate of $100 an hour to her past mental anguish, you get to this figure of $3.7 million. That's the past figure. That's the past mental anguish. Mental anguish is one of the categories under battery for the question 18. Now we have to do the same thing for the future. And you'll have the life care tables back there with you there at exhibit, the mortality tables. Exhibit 2060, there's page 002, and there's pages 47 to 50. So you can check that our economist, when she came in here, and what we're representing to you is Maya's life expectancy from those mortality.
Bobby Graham, yes. Yes, he did. I did catch this. He said he does a great job of telling the jury to tell what numbers to look at. Tells them to write it down. Yes. In the math part, when I say you have to explain math, you have to take, I can represent to you. I will represent to you. Take these things out of your language. Take it out of your language. Simplify it down and say the numbers again. So Peter tells them to write it down. You can tell them to write it down, or you can be very obvious, perhaps in re-enunciating or repeating a word or a number, 3,297. Remember that number, 3,297. Now you multiply that by the number of days, 300. You have to slow it down, make it super simple that it's obvious that you are expecting the jury to take notes. Or you can be even more direct, like what Peter does. Tell them to do it. This is the hard part. You have to ask them to do something. They cannot give you what you do not ask them to give you.
Value tables. So we do the same math. We take the hours per day that Maya experiences mental anguish. We take the days per year. We take the years remaining in Maya's life, and we multiply that by $100. And you get a figure of $34.8 million for Maya's mental anguish. And if you go advance one more here, you'll get a total for her past and future mental anguish. Then you allocate that among the different claims. If you'll back up to slide 55, please.
We have,
in addition to the human damages, we have economic damages. And these are directly from the testimony of Christy Kirby, the economist, and the life care plan. This is when I was writing on the whiteboard over here. If you go to slide 56, this is the essence of what Christy Kirby told you. At a wage or an annual earnings of approximately $100,000, which we would submit to you underestimates Maya's potential before this all happened to her. The loss of earning capacity is $5 million. And then you have future medical expenses. And this was based on the testimony of Dr. Bafolko and then Christy Kirby coming in and giving you the present value calculation. $10 million. So now you have economic damages to Maya Kowalski of $15 million. And you'll see this ability to compensate Maya Kowalski for her future medical needs and her future loss of earning capacity in several different places. For example, you'll see the ability to compensate her for future medical expenses in question 17 on the verdict form. Then
everyone in the chat's already highlighting it. You guys have highlighted it. Yes, I made the comment. 10 minutes. You need to give him more time for this. Trust your case. Trust your case on liability. Trust your case on liability. Damn it. Trust your case. Give him more time. Give him more time. He's rushing. You can hear him rushing. This part drove me nuts. And the thing is, you can't do this first. Everyone says you have to do this first. You cannot do this first. If you do this first, if you come straight to the jury and say, jury, here are the numbers you have to find, here are the juries you have to do, or like, here's the numbers, multiply this by this by this. And the jury's like, wait a minute, you just put the cart before the horse. You can't put the cart before the horse. You have to let me find liability before you get to the numbers. That said, Anderson's closing was impactful. It was impactful.
I need to go to the verdict form for just a moment to look at question 34 and 36.
Oh, he's going to win some points back from me here. He's going to win some points back. I'm going to give him a lot of points here.
And then 36. And Mr. Anderson discussed this for a moment, but to unlock your ability to compensate and deliver justice, not just to Maya, but to Beata and Jack and Kyle, you need to answer yes on question 34.
Yep.
That Johns Hopkins All Children's Hospital, through its extreme and outrageous conduct, inflicted severe emotional distress on Beata, even before her death. You need to answer yes to that question. And then you'll advance to question 36 on the next page. And question 36, you need to answer yes. And if you answer questions 34 and 36 yes, then you have the opportunity to do justice for Jack and Kyle and Beata.
Perfect. Perfect. Tell them what to do. Mr. Whitney, I believe what you are telling me is the appropriate outcome. You're telling me the appropriate outcome. Dear sir, what do I do to side with you? How do I tell you? And how do I side with your outcome that you have illustrated to me on this really complicated jury form? Please tell me what to click. He's like, check 34. If you want to give justice, check this box. If I'm the jury, I'm going back in that jury room saying, I remember this part. Flip forward to 34. Check that just to make sure, because I remember that part. Oh, whoop, 36. Check that part too. There we go. Now let's go back to the beginning and take this one step at a time. That's effective. That was very effective. I love when they pull in the actual jury questionnaire and they say, or the jury verdict form, and they say, this is what you have to do. Here's the box that you're going to check. And then it's even better if you actually go in there and physically check it and like to show this is how easy it is. Look, just check, check. Brilliant. This was great. I'm not going to make you all cry because he makes the onward connection, and it's very difficult. We take a 5-minute recess and we go to Mr. Shapiro's closing. Mr. Shapiro, I thought, did very well. His client, before people start jumping down my neck and his neck, remember, this is his job. It's his job. And he does a good job at it. It's not easy. He loses me at the end. He really loses me at the end, where he starts talking about the money and the dollar figures. But he makes good points. It's right up until the end when he starts talking about money. Oh, fucking drives me crazy. If you think you did a good job, and I saw Peter talk about this too. If you think you did a good job, don't say, but if you think we didn't, give him this and not that. Sir, respectfully, how can you tell me that you did a great job and then tell me that if I disagree with your assertion and somehow agree with the plaintiff's assertion, that I should give them less money than what they asked for when I just decided that what you told me was a crock of shit. That part was tough. The beginning is solid.
Everyone, please be seated. Members of the jury, I just want to confirm while you're away, you did not discuss this case amongst yourselves. You did not do any investigation and you received no information. Okay. I also want to confirm that no one approached you about this case. Is that correct? And you've not seen any media coverage about this case. Is that correct? Mr. Shapiro, you have the floor, sir.
May it please the court. Good morning. I wanted to start with a couple of thank yous, if you'll indulge me. I want to thank the court for conducting this trial in a civil manner. This is a civil justice system. I think it's a testament to that. I wanted to thank Deputy DeMizio and Deputy Coley for keeping this courtroom safe and helping you through the process. I'd like to thank the Kowalskis for listening patiently and respectfully. I know that a lot of the things I've had to say have been tough for them to listen, but they've listened with grace and integrity, and I thank them for that. I'd like to thank my trial team sitting behind me, too numerous to name, but we've all been here. I'd like to thank you from the bottom of my heart for your support.
Now, at the outset, I will say thanking the Kowalskis is the right move. It's the right move. Stop repeating. It's the right move, but it can come off as disingenuous if you don't have the jury on your side already. So it's a risky move to thank the Kowalskis right there in front of the jury. If the jury just heard the plaintiff's case and then you stand up defending the hospital and say, I'd like to thank them for sitting here and listening to the stuff we've been saying, they can perceive that maybe not the way that you want them to. I will say that I think that it's a respectful thing that I would like to see brought back into the courtroom. I'm not going to fault him for making that remark. I'm just saying it was a risky remark. And then you thank the jury, and then you get into what is the scripted part of his beginning.
Service. This has been a long 9 weeks. Indeed, we started in the summer, but you've listened patiently. You've asked great questions throughout the process, and we appreciate your active engagement. But most importantly, I want to thank these people, the people of All Children's Hospital, and they've given me the privilege of standing before you to be able to tell their story. And that's what I plan to do during my time. They want you to know that All Children's did not harm this family. Not just the people here, but the people back working at the hospital. They want you to know that. We are here because we believe on behalf of the hospital practiced safe, evidence-based medicine, and we're here to defend the hospital's right to practice that medicine. And I've put up a list here of the witnesses because you've heard from a lot of people. So when we talk about witnesses, if this helps orient you to who's who, this on this side is who I represent. On the other side are people you've heard from that I do not represent and who we are not responsible for. It's almost Thanksgiving, so I put up the pie. And I don't know if this is an interesting memory, but way back when we did jury selection, you may remember we had a little bit of fun. We talked about pie and what your favorite pie was. And I've learned that some people don't like pumpkin pie, which is incredible to me, but that will be an interesting topic at Thanksgiving. But the reason why we had that moment was because there was an incredibly important question that followed it. Can you judge this case fairly based on the evidence? Can you hold the plaintiffs to their burden? They have the burden to prove the claims. And in fairness, Mr. Anderson and Mr. Whitney have welcomed that burden. And most importantly, can you reach your decision here based on the facts and the law and not on sympathy? And that's important because this is a sympathetic case. Nobody is denying that this is a sympathetic case. In fact, if you didn't feel sympathy in your heart, you wouldn't be human. But the judge has instructed you, and everyone here took an oath to make sure that their verdict is reached on the law and the evidence and not on sympathy. In order to know how we got to All Children's, we need to take a little bit of a step back, and I think it's going to be very helpful.
Okay, so where he goes is effective. Sorry, block the face. Where he goes is effective. The preamble to that, no. The preamble to that of reminding the jury that this is a sympathetic case. And the intent focus on that of disassociate yourself from your sympathies might have the exact opposite effect. But where he goes with it is effective. He highlights these different quotes and he uses them effectively.
If I can walk you through the treatment and what happened leading up to All Children's, because it's almost like a Quentin Tarantino movie where you saw a bit of the end, then a bit of the middle, then something in the middle, then something at the end. And what I intend to do with you is walk you through. And actually, the case begins before the 4th of July. You heard from Dr. Wyndham in his deposition testimony. He spoke fast, but these records are in evidence. And by the way, if you look in the lower right-hand corner, if there's a document you want to see in the jury room, I've tried to reference every single one. So for example, this would be Defense Exhibit 3050, 1 through 4, if that helps you, if it's something you want to see on your own. Before the 4th of July, before the incident, the Kowalskis went to Dr. Wyndham with the cough that you heard the audio of, and Dr. Wyndham said, there's nothing that I can see wrong with the lungs. The pulse ox is normal. And he says, something really is not right. This is not just asthma. He advised the Kowalskis to watch the steroid use and noted at the end that the parents were arguing about taking her to the emergency department and questioning the role of family dynamics. We know from this picture that on July 3rd, Maya and her brother were participating healthy and normal in the local July 4th parade. We also learned about CRPS. We learned a lot about CRPS. We learned from almost every expert here that it starts with an injury. But what we saw when the Kowalskis presented to the Sarasota Memorial Emergency Department, that the onset of this was getting worked up about the 4th of July. And when the fireworks began going off, there was some trouble with breathing. We know in the note that Beata Kowalski gave the prednisone and IM, intramuscular, a shot of Benadryl with no resolve. And then even at this very first visit, this emergency doctor, Dr. Brett Williams, noted his concern of a potential psych component. Let me orient you to the several presentations of the All Children's Emergency Department. The first one was July 6th to July 11th. And by this point, Maya had presented in a wheelchair, less than 72 hours after the initial onset. Of significance, she was seen by a pediatric neurologist. Very early on in the presentation, Dr. Joseph Casadante of the All Children's Pediatric Neurology Service wrote that this was an unusual presentation. It's associated with what he believed was a habit cough, putting his impression in agreement with Dr. Wyndham. Physical therapy was consulted because of the presentation in a wheelchair. And at this point, we start to see what starts to appear more and more in the records, which is that Maya, patient, wants to make sure therapy stops, physical therapy, occupational therapy stops when she says so. And that, according to mom, Maya needs more pain medication. Maya was discharged from this hospitalization on July 10th. And the initial diagnosis was chronic steroid use and a habit cough. Less than a week later, Maya comes back with her family to All Children's. Now we're on July 7th, 17th to 20th, 2015. So this is still more than a year before she comes to All Children's. And when
I will say, I am not one for slideshows or slide decks and closing arguments. The Hopkins attorneys have done a great job in opening and closing. What the hell, man? How many times do you guys have to practice this? How many times do you have to practice this to get it right? I'm just curious. I'm jealous a little bit because that's a lot to get right. And it's really organized. Damn it. The slide decks they're good. They're usually really distracting. This is not. This is good.
I want you, this is an important piece of information. This is from Joint Exhibit 100854. When the plaintiff said to you in their case, nobody at All Children's ever suspected conversion disorder or somatization. Remember, he said that to you prior to October 2016. It's right here from Dr. Kilgore. In the history and physical from July 17th, 2015, her differential diagnosis included psychological pain, conversion disorder, and somatization. And it's important because in opening argument, you may remember the plaintiff told you that at the end of this admission, this is right before they go to Lurie's, the doctors threw up their hands and said, Mr. Kowalski, we have no idea what's going on. The record says otherwise. The record says even at this early date back in July of 2017, the differential diagnosis of a psychological pain conversion disorder was in the records. Now, again, conversion disorder does not mean that Maya's not feeling real pain. Let's make that very clear. But there's a psychological component to this that does not require ketamine, and we'll talk about that. Now, what we unfortunately start to see a pattern of is what the defense would respectfully suggest is a history of unnecessary medications given at dangerous doses. Unnecessary medications that are given at dangerous doses. And it started back at this admission on July 20th, 2015. And it started when the discharging nurse noted Mrs. Kowalski was adamant that they would need a PICC line, peripheral.
Note how far back he went. So note how far back he went. July 2015. This is part of his closing, and this is where he starts to gain points. He starts to make progress. He starts to make points. Boom, 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 boom. And then he gets to the money. It's like, dude, off the cliff.
Inserted central catheter for transfer, but the All Children's team warned that doing that with a commercial flight was both inappropriate and dangerous. The Kowalskis made their way to Lurie Children's Hospital. For a second opinion, totally appropriate. They're going back to their trusted children's hospital in Chicago. World-class hospital. And we heard from the emergency department physician, Dr. Petzenberger, that upon his first visit with Maya in the emergency department, Maya was able to show good upper and lower extremity strength by kicking with both legs. And now his diagnosis is fitting that of Dr. Kilgore.
That's a good point.
That the behaviors were concerning for a psychiatric component, possible conversion disorder. And again, this is not a question of somebody saying that Maya is faking it. This is real, but it calls for a different treatment pattern. Now, a lot of what you heard during cross-examination was, are you an expert in CRPS? You remember this. Every doctor, are you an expert in CRS? Well, they met one, and you heard from him. Dr. Gatti Revivo from Lurie Children's Hospital, board certified in adult and pediatric medicine. He testified he has significant experience with CRPS. He told you it was regional, and he used the Budapest criteria. And back then, he started what we believe is the evidence-based medicine, and it's simply this. CRPS or conversion disorder, the treatment is physical therapy, occupational therapy, and cognitive behavioral therapy. And at Lurie's, ketamine, intrathecal clonidine pumps are not what they use. Then there was one of those things where we call sort of a dramatic moment at trial where my partner, Mr. Hughes, put up the picture of one of the scratches at All Children's that the plaintiff claims is a CRPS lesion and asked him, what do you think? He said it was a scratch. That was his opinion, which is going to go, we're going to come back to that when we get to the All Children's admission. She was seen by a pediatric psychologist, Dr. Lowry, who also noted an exam inconsistent with the history. And again, their belief at this world-class hospital was conversion disorder. But importantly, her recommendation, as she told you under oath, was for non-pharmacologic intervention for the pain. You also heard testimony from Dr. Elizabeth Byrne. She was a pediatric hospitalist that at that time was also assessing complete and normal strength in upper and lower extremities and believed this was triggered by conversion disorder and wrote it in her note at Defense Exhibit 3032-127. And she specifically wrote on that date back on July 24th, 2015, that the exam was not consistent with the history, which raised the concern for a psychiatric component. And this is the important part. She will likely benefit from a therapeutic program that combines physical and psychological therapy to address both weakness and pain access, and with the appropriate therapy, she's going to return to baseline. Remember that, because this is the exact recommendation that's made at All Children's, as we're going to see, and not just All Children's. The family returns back to the Tampa Bay area and checks into Tampa General Hospital under the care of Dr. Kornberg. Dr. Kornberg, on his very first visit, writes in his note, and again, this is at Defense Exhibit 3047-21, that there were some inconsistencies in his exam. That's okay, but his impression is now exactly the same as what Dr. Kilgore wrote at All Children's, which is exactly the same as what Dr. Byrne wrote at Lurie's, that this is psychological factors affecting physical condition. His first impression of the case. Then we get to Bonnie Rice. It's an interesting comment about Bonnie Rice in opening argument. You may remember it, you may not, it's been a while. But the plaintiff said, this is the Kathy Beattie of Tampa General. Like there's a county-wide or Florida state-wide conspiracy among providers who have never met each other. But they said it because they don't like what she had to testify to, because what Bonnie Rice testified to was that there was a psychological component, and then talked about some of the family dynamics that Dr. Wyndham talked about. And I don't mean to bring this up to cause any more embarrassment, but this is an important issue, because what Bonnie Rice said was that Maya was telling her about how her mom was working and how she was trying to get her attention. She talked about the feet going inward and outward volitionally. And she talked about how mom was respectfully asked to leave to see if the condition would improve, and it did. And that there were multiple stories about falls that Maya had told them at Tampa General, and they put her on video monitoring. Dr. Kornberg does his own independent reassessment a week later, and notes volitional movement in all extremities, but the performance is variable, and documents that Maya is now asking for more oxycodone when mom is present with her.
So he goes down this road of the course of treatment that existed years prior to Jay Hatch ever saw her, and then starts to talk about the different medications that she was on. She wasn't just on ketamine. I mean, we're not just talking about ketamine at high doses. We're talking about really impactful stuff. There were prescriptions for actual oxycodone. There were benzos. There were different things that she was taking. So, but again, I go back to this point with me and how I viewed this case. And I wonder if any of the jurors feel the same way. And I know I've been kind of long-winded about talking about this, but this case became less and less and less and less about medical malpractice. It became less about med mal. I understand that Jay Hatch, when you line these things up, had ample reason to suspect that it might be a different diagnosis. Okay, even if I'm there on the jury, get me to any one of these other circumstances. Justify that conduct. And the more that you focus on all of this stuff, the more I'm going, why aren't we talking about the important stuff? Please. Why? And then when he got to it, and he got to the battery and the discussions of the battery and the false imprisonment, it's not a matter of the time that the photographing by the hospital, however intrusive it might have been, was only for a short period of time. I deal in family law cases, and I can tell you that circumstances of that level of significance live in the child's mind for years and years and years and years. And I would strongly suggest that you find a different way to argue your point. It's not about how long the imprisonment lasted. And if that's the point you're making, allow the jury to reach that conclusion on their own. Don't say it out loud. There are certain things you just don't say out loud, because when you do say them out loud, they sound just as ridiculous as they do when you hear them in your head and when you think about them at length. Mr. Shapiro, if that was your daughter and you did not agree to the photographing, would you be asking yourself if that was the same, if it was just a matter of 10 seconds or 30 seconds or 10 minutes? Would that question even cross your mind? If I asked you that question to your face on the street, would you look me in the eye and say, you know what, Mr. Morton, you're probably correct? Or would you want to punch me in the face? I'm fairly certain it's going to be the latter. And to be quite candid to you, if I told you that, Mr. Shapiro, that, it's your daughter and it was just 10 minutes and a photographing that, yes, you didn't consent to, but we had a reason to do it. But you know what? It was just a 10-minute period. And you wound up to sock me in the face. I'd say I had that coming. I'd let you take a free swing, to be honest. Nope. You're not going to catch me making that argument anytime soon or ever. That's where he lost me. That's where the defense lost me. I can see the defense possibly winning on the med mal case. I can't see how they get beyond the battery and the false imprisonment. And I don't think the jury can either. Especially when we get to the rebuttal. Rather, the rebuttal close or second close, whatever you want to say, for the plaintiffs. Yeah, I was not pleased with that line of argument. Trying to make that argument with any of my nieces or nephews, you are going to have a black eye, and I am going to be calling some friends of mine to come and post bail. Just saying. That's just gonna be the problem. I'll spend a little time with a toothbrush in a cell. So rebuttal close. Strongest remark. Strongest remark. I have no doubt. I know Peter has kids. Peter has kids. I would never make that remark to Peter. No. Nope. I wouldn't make that. Imagine me saying that to Emily, Peter, Rick, Nick, Ricada, anyone with kids. Imagine me going up to them on the street and saying, hey, you know what? I know that your child was withheld against their consent and possibly disrobed and photographed. And I know that they didn't give consent to it, but we might have had good reason to do it. But hey, it was just for 10 minutes. Oh, man. Nope. I'm waiting for that punch to come, and I'm just tucking the jaw and making sure that the neck doesn't spin around and I don't lose equilibrium and get knocked out. But one, I'm not making that argument. So, rebuttal close. Anderson's finest work, in my opinion.
This is who they really are. This is a place where they call little girls who just lost their mom ketamine girl, and appear to have absolutely no problem with the fact that they knew this was coming and said nothing and did nothing. This is who Johns Hopkins is. They say, I wouldn't put anything past her mother. Put what past her mother? Trying to take care of her child? She can't perform this charade effectively 24/7. They're talking about a 10-year-old. Maya feels ACH is lying. Wonder why that is. What kind of doctor-patient relationship is that?
All right. So my pause game is usually on point. I will say, Mr. Reyes, I imagine that is you, sir, who did the pause and still images that we have of Kathy Beatty and Sally Smith. Pretty savage. And the fact that they have this displayed on one slide. Now, here's the thing about the rebuttal close. Rebuttal close is one of those positions where the individual making that second close, they know there's no response coming afterwards. So this is your opportunity to go all in. And attorneys take advantage of that. It's their last word. It's their last chance. Rebuttal closing arguments, second closing arguments are always louder, more aggressive, more in your face, more just everything. Because they know there's nothing else coming back. And because they can stand up and deliver this rebuttal close with what they say is righteous indignation. My gosh, did you just hear what this person said? And they know that person can't come back up and refute anything I say. So I am going to go all in on the argument. This is the very definition of going all in on the argument. This slide, boom, 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 boom. All the best elements of their case.
What kind of pediatric relationship is that? Why would you want to keep a child there when the child doesn't want to be there and just wants to be away from you in this first week? Maya feels J or ACH is lying to her about her mother, that the doctors are lying about her parents. This should never even begin to start up in a pediatrician-child relationship. It should never, ever be. This is who Johns Hopkins All Children's Hospital is. It's a place that retaliates against its own employees for bringing things out that are negative.
Look at the text. All caps. This is all red. Johns Hopkins All Children's Hospital. Simple. Effective.
Negative. and retaliates against anyone, any parent who decides they want to do something different. All I heard the other side was, it's our standard of care. It's our standard of care. It's our standard of care. Who cares if it's your standard of care? A parent has a right to decide their child's own treatment. They don't get to choose it. And that's a lot about what this case is about. It's about an organization that is so screwed up that it actually thinks it's a good idea to force parents to accept their way of doing things. And if the parents don't, then they've got to find different ways to punish them. That's where all this stuff came out of on the 7th. They disagreed. Beata, a registered nurse, an infusion nurse, knew what she was talking about and had 15, 16 months of experience as to what worked and didn't work, made the greatest mistake you could ever make to these people. She said no.
Look at the difference between his argument in his first close and his second close. First close, make sure I hit the points, make sure I get all the things checked off the box. Second close, he's operating off a bullet point list and he is just letting himself go. This is effective. People perceive, just me being someone on YouTube, people can perceive when you're being genuine or not genuine. And they can tell when your heart is invested in an argument and when it's not. Mr. Shapiro, I don't know that his heart was in all of that argument. Mr. Henderson, his heart's here. He's here. Comes out swinging, and he did it right. This is how you do a rebuttal close. This is how you do a rebuttal close. That's a freaking repeat again. Rob, stop repeating yourself.
They still don't freaking get it. They still don't freaking get it.
I kind of would have, if I was Anderson, the repeat, he did it there. They still don't freaking get it. They still don't freaking get it. I probably would have let that last F kind of taper off. They still don't freaking get it. They still don't freaking get it. But this is fucking solid. This is solid. I think, personally, the jury got to liability on at least one or two of those counts within about 3 minutes of going back in the jury room. I think the hospital is liable on at least one or two counts. Which ones? I don't know. And right now they're sitting there looking at a spreadsheet and going, how do I do the math? Make the math work. But as far as liability, this was probably about as solid as a rebuttal close as you could have gotten. But you got to get the math.
Here are the punitive damages questions. 5, 10, 15, 20. Those are 4 opportunities, if you agree with the plaintiffs, that this is completely and utterly intolerable. Punitive damages are for willful, wanton, and malicious character behavior. There's absolutely no question that risk management, with the concurrence and knowledge of the general counsel, which is as high as you can get in this, planned and instituted this entire idea of stripping this child down, taking photographs of her, not letting the parents know, against the child's will. They knew. They instituted this from the very top of this organization. What does that tell you about what's going on here? What kind of ultimate lack of humanity? There needs to be some captain of this ship, and there never was. It was totally dysfunctional, the way this hospital operated. No one was checking. No one was making sure to see how this child was being taken care of. No one was looking to see how their own employees were behaving. And it wasn't just one. Yes, it has to be clear and convincing, but when you have internal memoranda from the highest up in the hospital.
By the way, I have always been a big fan of the eyes closed argument. Always. And the reason why I say that is because there are certain times when I'm speaking where I need to shut out the outside world to find the words that I need to use to convey. And that I will actually shut my eyes and go back into my brain internally. I will process internally and try to think of how to explain something in a way that best illustrates the thoughts that I have in my brain. It's not blocking that you see. That's not what you're doing here. I'm internalizing and thinking. This is me computing. And I've always been a fan of when you are trying to find the right words that you can do that. Now, you can't do it the whole time. You have to make eye contact with the jury. But if the jury sees that you are trying to process and find your words carefully, there is impact there.
Down to a Kathy Beattie, telling her to do something like that. That's clear and convincing. That's from the highest part of the hospital down to do something despicable. You don't do that. I heard a lot about attacking Beata. I never figured out why. If they really, okay.
This part is really important.
Again, pardon me if I'm confused on this. If these doctors who are all licensed and specialists in CRPS and pain control prescribed what they think was too much medication, why go after mom? Why not go after the doctors? Where have you seen anywhere where anything that Johns Hopkins did questioned the actual doctors writing the prescriptions? No, it's too hard. That's too hard. That might cause problems. Now, it's easier to go after Beata. Plus, she insulted them by not agreeing with what their routine was. Think about this, though. If the whole point here is that Beata, who is just trying to take care of her child, by the way, is taking her child to places and trying to get treatment, and these doctors are prescribing all of these excess medications, or this won't work, or that won't work, why are you attacking the mother? What possible good does that do? After the Mexico trip, one of their pulmonologists, who actually was a very nice man, Dr. Kreisman, saw Maya, having seen her 2 times before Mexico, and now 5 months after Mexico, and says, talking about the treatment in Mexico, the long-term ketamine infusions, this is a new child. Do we have that? This is a new child. She's bright. She no longer appears to be in pain. On physical examination, she's examined in her wheelchair. She is a completely different child from the last exam, which was 2 months before Mexico. By that, I mean she is not in any pain. She is not moaning. She is smiling. She is interactive. She is very engaged. Oxygen saturation is 100%. Weight 25 kilograms. This is an experienced Johns Hopkins doctor. Remember I said there's a lot of the outside doctors I thought were trying to do their job. Apparently, Dr. Kreisman was. And 5 months after, here he is saying, this is a different child. That's their own physician saying that. And please keep in mind, around this time, their surgeons also put the port into her chest to facilitate the ketamine infusions. What you are seeing here is an incredible example of revisionist history, picking little bits and pieces out of the record and trying to fashion them into some blame? What did the Kowalskis do wrong here? What was the purpose of all this? Other than arrogance and the belief that
Oh, that part. This rebuttal close was delivered the way it needed to be delivered. If you have an ally on that jury, you need to fill them with this righteous indignation. So that if there is a detractor on this jury, if there's someone that's pro-hospital on the jury, that when that person who's pro-hospital says, but I don't think they're liable, this person on the jury that you have just fueled with the fire of your rebuttal close goes, are you kidding me? Whether you believe it or not, this is the purpose of the rebuttal close. The rebuttal close is to basically, that's the fire. That's when you stamp your firebrand on it and be like, that's my mark. That's where I'm leaving it. If I'm going out swinging. This was very good. It was very good. That's where I'm going to leave my recap of the arguments. Oh, my hair. Hat back on. So I know that there were jury questions. They focused around economic damages. How are we going to calculate this stuff? First, we want to see the testimony, then we don't want to see the testimony, and then it's, I can't find the documents, combined by the fact that the document, like the judge, not the judge, the parties sent back a USB stick, like a little thumb drive that had the 3,000 plus exhibits and a lovely index that they have been working on that explains what the exhibit is, where to locate it, what file folder it's in. But the thing is, that little index had this lovely thing after it, .xls. Huh. Well, the computer that was back in the jury deliberation room didn't have Microsoft Office Suite. So that .xls, that Excel spreadsheet, I can't open it. Just so the question, people have been opining about the question being, how do I find this shit? Teach me how to find this shit. The judge says stuff, he replaces it, and how that seems to be outside the realm of decorum that would be acceptable in a courtroom. 2 points to make. One, the judge has established a comfort level and a rapport with this jury, and so have the parties, and so have the attorneys. The attorneys are even kind of chuckling at some of the remarks the jury is making. It's not because it's funny. And I don't want you to confuse my statement for an impression that I'm giving you that the jury doesn't take this seriously. I think they take this very seriously. I think that's bolstered by the fact that they've been deliberating this case all day today and most of the day yesterday afternoon. They take it seriously. But when you're a jury and you get sent back into the deliberation room, and the first task you do is to elect a foreperson, you elect a foreperson, the foreperson says, let's do a straw vote. Let's see where everyone stands right now. Go ahead and say, how many think liable? And you go around the room and you kind of discuss why you think liable, et cetera. And let's say that you get to some semblance of a consensus, or you have a split, 4-2, 3-3. And the people that are saying, I say not liable, but I'd be curious to see the numbers. And then you're sitting there going, I say liable, but let's go ahead and pull the numbers up. And then you finally open this laptop. And the laptop that you have been given, this magical thumbstick that's supposed to have all of the documents that you've been promised along the way. First of all, how many of those jurors have been taking notes, and how many of them have wanted to crack at those documents themselves? So you've been given this promise that you will receive this gloriful, this wonderful USB thumb drive that's going to give you the access to the materials that, has been spoon fed to you along the trial, but you want to see yourself because you don't trust lawyers are giving it to you. You want to see it yourself. And you go to open it, and the file extension is something the computer can't open. And you're going, well, maybe it's like other computer issues. Maybe it's just user error. And so you're looking around the computer and trying to figure out how to open the other file types. You're going, well, son of a bitch, I can't open the damn thing. You don't want to ask a question. So you're sitting there after several minutes of arguing with your fellow jurors. Yeah, the note you might write might be a little bit spicy. And the judge took it in proper jest, but also redirected the jury. I don't see anything wrong with that. I think the jury takes their job very seriously, and I've been impressed with how they've handled it. And the judge's admonishments have been increasingly impactful in that, you might be walking to your car at the end of the day. You cannot discuss the case, even when you're walking from the courthouse to the car. And the judge says, we have dismissed the alternates. There is no more safety net. It rests with you. Please behave. And I think the jury is going to take that mission to heart. So let's catch up on Super Chats real quick. I have a quick plug to make. Wait, I thought it was, I got the participant. I can still do that. Okay. So for those of you who are new to the stream and did not see me over the weekend. So over the course of the weekend, I participated in a friend of mine's live stream, 24-hour live stream to benefit the Salary Children's Hospital. And I auctioned off 6 pens. I think the 6 pens we auctioned off earned in donations $19,000 to the hospital. So my friend Ian Runkle, who I appear with quite often on this channel and his channel, does a remarkable thing every single year where he does full 24 hours of a live stream to benefit the Salary Children's Hospital. The names that you see are companies, and these are annual donors, and Mr. Runkle is in 4th place. You will see that he is at $107,457, and the 3rd place spot holder is a company, the Mindcrack Group, of $108,035. I have loved, absolutely adored the opportunity to help lift up what people perceive as a very small community, the people on YouTube who just talk about law but are passionate about it. I've loved to see them go head to head with these companies who put marketing departments behind a marketing campaign saying, look, that we care. I'm not saying that companies don't care. What I'm saying is that the little guy gets dismissed a whole lot. And when enough of those little guys are around, chipping in a little bit here and there, they can donate a whole lot for a whole lot of good. So I've pinned a comment in the chat. His fundraiser is still open. Like I said, I donated 6 pens. We earned 19,000 through the pens, and I spent I don't even know how many hours on Saturday on his live stream trying to auction off different items for charity. I would ask if you guys have a couple of bucks here and there. Just those of you who are willing. I did donate all the proceeds from FNF on last Friday. I donated all of those to the charity. So there was $2,000 in the kitty, which was $1,200 from FNF plus $800 of my own that was there, and then the pens. So I would love to see that number go above the number 3 spot. If we can get him number 3, that would be amazing to me. I would be ever so thrilled. So just a thought, if you're able, just a thought. I will go ahead and pull that down. We'll catch up on Super Chats, and then I will bid you adieu for the evening. Z Seltzer, info, Ian is still in 4th place with 10,000 more to get into 3rd. Can we get him there? It's not even 10K more. It's like right now we are, what are we? $500 away, $500 away to third place. Renee Fields, would sanctions still apply if defense wins? Yes. And that can be applied in judgments notwithstanding the verdict. I don't know how likely that is. Right now, I want to wait till the jury comes back. Manders, why is so much time and attention going toward appellate issues in the record? Is there an immediate assumption that both the case will be appealed by either or both? Yep. It's going to be appealed. I would say the threshold for appeal is if it is under a $10 million award, Hopkins will not appeal, but the plaintiff will. If it is over a $50 million award, the plaintiff might not, well, the hospital will appeal, the plaintiff might not appeal. I don't know. The numbers that we're talking about is a guaranteed appeal. It's going to be appealed. AEG got my certification for deposition transcription. Congratulations. Starting training with my #1 choice for long-term contract next week. Health issue still at issue. Still doing testing, but good news, right? That's phenomenal news. Congratulations, AG. I hope you enjoy it. By the way, court reporters have some of the best stories in the whole wide world. Literally some of the best stories you will ever hear. Find a court reporter, ask them about the craziest case they've ever been involved in. And then ask them about the 2nd, 3rd, 4th, 5th, 6th, 7th, 8th, 9th, 10th. All 10 will be better than like the most fun story that I can ever come up with. AG, why do you think the defense didn't jump on the strike suggestion right away if it was so advantageous? Ego issues or forest for the trees? No, because having the jury instructed that the jury should disregard the testimony of their expert is really damaging too. That was picked the least painful of the most painful situations. Marcia, how is it okay for Hunter blatantly not follow the judge's order to turn over IG report? It's not. It's not, but how far is the judge going to go to punish it? And at what risk? Because if the judge starts sanctioning out of frustration or a little bit too far, then does the court really want this to be put at risk via appeal? No, you want to stay within your lane. You want to try to be measured in your response. Cynthia Kramer, Rob, why did Maya side hire their own court reporter? I didn't know there's a thing. So they might want the dailies. The dailies are daily transcription, plus they might be have their own court reporter because they want to manage the entire record. So let's say, for example, there's a conflict in the testimony. 2 people are talking simultaneously, and your court reporter gets one version, their court reporter gets another. But the words are really impactful. It'd be nice to have that as an asset. Retired Nana, is it Court TV or Law and Crime? It's whoever has the media feed. I think Court TV has the feed and Law and Crime uses it. I'm not sure. Amy Miller, Rob, how do we make it stop? How do we demand this? Write notes to the networks. Write notes to the networks. That's what I can think of. E. James, feels like the hospital's been allowed to be very dishonest, problematic. Kowalski's not the only family who were allegedly impacted. How does this differ from withholding evidence? Are you a criminal trial? Not a whole lot, and not a whole lot is done in those cases either. I wish the system wasn't this way. Really do. But my job is not to spout rainbows and happiness. I mean, kind of it is, but I also want to be honest with you. So we can make it work a little bit better if you start hitting people with sanctions a little quicker. AG, can the defense get in trouble for lying to the court about these reviews work? How do we look forward? Is it a commission of tarot card readers? It was misleading, but I wouldn't say it was an outright lie. JM, is Mr. Hunter allowed to lie? Like I said, it was misleading. I wouldn't say it was an outright lie. Surveys do not look forward. It's a present time and look back. It was misleading. It was not an outright lie. Miss Jules, Florida. I wish you'd respond to my super chat. I did. It took me a minute because I do get caught up in the what we're watching and what we're covering, and I apologize for that. I did catch your super chat about the referendum on retaliation in the hospital setting, and I tried to comment on that. And I think the entire system needs a little bit of rework. Claude, I mean, how do you cross such a good witness effectively? Very carefully, or you just sit down. Ms. Jules FL, the system is broken. Rob, You and I don't disagree on much. Brandy celebrating my birthday today with you on live. Happy birthday, Brandy. Cheers to you. I hope that you're enjoying your vino. Terry Zelensky. Oh my God, how about props to the paralegals who have to train baby lawyers? Yep. Y'all are amazing. Every one of you are amazing. Every single one of you are amazing. They're baby lawyers, and we don't mean that disparagingly. It's actually a remarkable term of endearment. They do need training, though. The most dangerous thing in the world is an attorney who just got their bar license. Lady Losandra, Rob, sorry, compound question. Would you give legal advice to us if we contact your office? Yes. If you guys ever really do have an issue in Virginia involving domestic relations litigation, you can contact my office, Whitbeck Bennett. And you can actually schedule a meeting with me and I can discuss that. I've had a few people who have seen the YouTube videos who have had legal questions regarding domestic relations in the state of Virginia, the Commonwealth of Virginia. And I've been able to meet with them and discuss it. Lady Losandra, I know you practice family law, but what is it? Do you do divorces? Yes. Kids, lawyer? What exactly in family law do you do? Everything. Custody, visitation, child support, kids attorney against school, parents attorney against school, parents against parents, anything like family law. That's kind of the practice. And then bankruptcy law as well to try and get people out of financial trouble. Magical Mary, Rob, why did they not ask for punitive in the IIED claim? I think that they thought it was going to get stricken. I think the causation issue is a real big question. That's where I think the causation issue was a difficult thing for them to tread. Not that, Mickey. Rob, you have to keep doing commentaries in these cases, perhaps just summaries, please. We will be having withdrawal after this trial. I will try. I can't do it daily, though, guys. It's really tough. Gamer Ducko, RE the photo shooting NCB lap thing. How impactful do you think it'll be? It's mostly a female jury. Pretty impactful. Females are critical of female witnesses, statistically speaking. Gingy Prob's comment, my wife and I live in DC Metro. She has chronic illness. We're at Hopkins 2 to 3 times a year. They're amazing. Hopkins, Baltimore, I've heard great things of. Great things. I've had clients who have gone there. I have a friend who's gone there. Great things. I hope J Hatch was an anomaly. It's turning around. Possibly. Karen G, please remind me why Maya wasn't transferred in the end. Thank you. Wasn't transferred because, well, plaintiff's case was that they had Munchausen by proxy on the transfer diagnosis, and the defense said that they just declined the transfer. Heather, one thing defense never answered for me is if it was not CRPS and instead Munchausen by proxy, then why did they not try in any other way to get the mother into any kind of treatment? Because they're a children's hospital and they can't diagnose that in the first place. K-Rab, I meant Peter said the same thing about them getting to battery and false imprisonment, but not med mal. But I get it. I'm a mom. I would have knocked Kathy Beatty on her butt. Yeah. Kathy Trout, I'm not accusing anyone of anything, but this looks like making of a certain type of content. We have mentally ill people out there. I'm not going to opine on whether that was or wasn't, to be honest. Petty honest throwaway. She said no, that was very powerful, particularly since we live in a society that pushes past no quite often, regardless of gender, but does this more to women and particularly immigrant women too. It was a choice of phrase for sure. Happy Annie, if punitive damages are 3 times compensatory, is it all 3? Is it 3 times all or just that count? From my understanding, it's just that count. In my experience, it's just that count. RK, he makes powerful parallels. Kept against her will. It was only a few minutes. She said no. You say shit like this about my kid, I'll drop you. You're not alone in thinking that. Don Burke, the hardest speech is to persuade to what you are saying. Oh, to persuade yourself to what you're saying? Perhaps. Emily Rusher, go Pack. Go Pack indeed. Go Pack. Aaron Richardson, thank you very much. And thank you for thanking for the dedication. I enjoy this coverage. I like teaching. And I hope it's an opportunity to learn. Hannah S. just finished pillowcases to donate to Children's Hospital. Wonderful. Nisa Hauer, Runkle also boosted some other people. I saw that. The man's heart is literally gold. Um, he's a solid dude. And you guys, you have him up at 107,822. So you have him, you've increased his donations by like $300 since we've been talking. So now he's just $213 shy of third place. Blessed in Texas. Thanks, Rob. Must go to bed. Broke both hands yesterday. Ooh, I'm really sorry. It's really hard. No, I appreciate you. Why are you typing? Blessed in Texas. Why are you typing? Broke both hands. Stop typing. Get rest. No, I appreciate you. Stay professional and sweet and kind. Remember now, can't wait for sanctions. Thank you, Blessed in Texas. I need to get shop stream going. I can't guarantee this weekend because I have a Friendsgiving this weekend, but I will get a shop stream next week. That I promise. Judy got this. Ian topped off my daughter's first extra life stream. Now she can't wait to stream all year for them. He always pays it forward. So will we. Like I said, there's a reason he's a good friend of mine. Kathy just donated. Let's bring Ian a third. He's a really cool dude. Matt Bond. Good day, Spiffy, legal mumbo jumbo, talking brother from another mother. Good day, Matt. It has been too long since I've heard you say that or heard myself say it, but hearing you say it. Thank you, sir. Lori Webster, thank you again for all you do. Seriously, thank you. I sent you an email. Ari, auction item. Did you get it? Yes, Lori, good point. So auction items, I have those emails. I am sending those out tomorrow. I was out of town yesterday and Monday, and I had trial today. So tomorrow, I'm back in front of my office where I can actually send those things to you. So if you bid on the auction items or you had auction items to give away, you will be getting an email from me tomorrow. LJ Peach, can't they be held in contempt for not producing the documents? They can. I don't know if they will. Susan Ferrier, Saturday was amazing. Thank you. Thank you, Susan, for all that you contributed as well. Drama Llama, hello. Normally I'm replay crew. Always fun to catch live. Glad to see you here. Baby steps. No interns who just got their MD are most dangerous. RNs have to do the training. I can see that. I can see the equivalency between the interns in the MD and the RNs training versus the lawyers and the paralegals. I can see that. Kristen M96. Is there a cap on what they can get? Like in Virginia? Yes. Punitives is 500,000, I think. But the jury's not told that ahead of time, so they can award like 2 million, but then the judge has to adjust it down. KPT, my money has it going, is going to Runkle's charity. Heart you too. Thank you. That means more to me than the money coming this way. Trust you. Trust me. Mujer Barroca, the judge called it a materially false representation. Is that not legal speak for a lie? Yeah, it is. It is. Heather, Runkle's in third. We all did it. Let me see. Did we really? Yeah, you did. Yeah, you did. Yeah, you did. You got Ian in third place. He's third place. Hang on. Share screen. Snazzy Trinkets Jewelry. You got Ian in third place. Hang on. Let me see. Find that again. See if I can find it and then screenshot it and send it to him. Snippy tool. Let's see. Ian Runkle. Sir, I sincerely hope you're awake right now. I know you are. You're always awake. Ian Runkle. I'm going to text you guys while I'm sitting here for a minute. You guys keep going too. You have them at 109. Oh, you guys are freaking awesome. Every one of you are freaking amazing. Oh, oh, Ian, I hope you wake up and shit a brick. I don't mean that in a negative way. I mean that honestly. Ian, I hope you wake up and literally shit a brick. I mean, however uncomfortable that might be. But either way, it thrills me to my core that you, sir, have achieved. This is the same person, by the way, who was concerned they were not going to meet their expectation of $50,000. And I was very much in the mind of saying, "Oh no, 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 no. We're gonna get it. We're gonna get it." Um, he's a really good friend, guys. And he does amazing things for a lot of people without a lot of ask in return. Really. Doesn't ask much. Maya recap tonight. Chat gave you a push. Like I said, y'all are some amazing people. I've been ever more impressed every day that I am on this platform discussing these things. I'm ever, yeah, y'all are amazing. PU, Rob, if it's possible, please review Dr. Dolan's Cross by Whitney, Part 50 of Recovery Addicts coverage. In my opinion, it prepared fertile ground for the IJ and Dr. Cochran's testimony. In rebuttal, Dr. Dolan, 50 RA, make a note, IJ, and rebuttal. Okay. I will take a look, my friend. Thank you. AG, last super chat for the night. Thanks again for the incredible community and the recaps. I've used them for practice and plan on sticking around. Thank you, AG. I'm glad that you have enjoyed the content. Magical Mary and Ian worked so hard. He got sick over the weekend. Send love. Indeed, please do. Sandy, when this community comes together, there's nothing we can't achieve. Sparkle farts. Thank you, Sandy. On that note, please give everyone thank the mods. Everyone thank the mods. Thank the mods. They've been doing incredible the entire time. Remarkable how much they have put forth in keeping these dialogues productive and conversational and respectful. So thank them. Thank you to the mods. Very much appreciated. And to all of you, there is a new owner to the pen featured in the outro. And that new owner paid a great deal of money to the Salary Children's Hospital for the benefit, or rather to have the designation as owner of the outro pen. Janice Arbogast, thank you. I love Ian, but you have a bromance. I have a bromance with a lot of the people that I spend time with and have fun with. So without further ado, I give you the outro pen, which was purchased during that live stream. Rather, donation was made and the pen was given in exchange. I bid you all a wonderful evening. I think that we're going to have a verdict by sometime around 2 p.m. tomorrow. That's my prediction. I think it's going to be favorable for Maya, and I think it's going to be in the realm of, we're going to go 25 million to 100 million. That's my ballpark. I don't know if we're going to crack over the 100 million mark, but we'll see. I'm going to be conservative in my estimates. Anyway, without further ado, I hope that you all have a wonderful evening. Enjoy the rest of your week. I will try to catch up with you after we have a verdict. And like I said, go make something. You'll feel better.